ними поговорить, а потом нажмете начать вебинар.
Слушай, пусть как неплохо проканала схему со смещением микрофона.
Звук уже сейчас включу.
Hello. Alberto, George, Daniel, how are you? Hello.
Hi, Arthur. How you doing?
Oh, not bad. Missing you.
Me too. Me too.
Yeah.
Same here. Same here. Miss all of you guys.
Hi, George.
Hi, Alberto.
Yes.
So
Yeah.
you're back. So you're in Italy then, Alberto? Yeah.
Yes, I'm in Italy now.
Fixed in Italy.
No. I'm in Italy for the festivities.
For festivities.
I'll be back on the 4th of January. And yeah, I mean, this event should have been in presence in Ukraine.
Yep.
we miss you guys, and of course we miss Ukraine.
Yes, another year is over, but yes, we haven't seen each other for 2 years.
It's crazy. You don't look any older though, Artnur. You look exactly the same.
What about next year? What do you think?
Next
Is
year,
is there a chance to cross up?
It's got to happen. Got to happen.
Gonna happen. Okay.
Yeah.
Yes.
Let's believe it. Yeah.
One would certainly hope so. Good morning, everyone. Good morning, Arthur.
Hi,
Good
Daniel.
morning, Daniella.
Good morning, Daniel.
Okay, I think that we are going to be in time and just follow the schedule. You know when your time is, yes? George, yes, George, I will pass you the microphone for a welcome speech. Yes, you know this.
Yeah.
Can you
Go on.
sorry to interrupt you. Can you remind me, Arthur, about the time, my slot when it starts?
Alberto, you are, let me see. Diego, Chalos, Carvalho, Kovalchik, San Simon. You are just after me. It's about 12:50 Central European time.
Okay, great. Thank you.
Artnur, all our videos are off at the moment. When you start, I suppose they'll be switched on so we can put our video on.
Yes, George, I will tell that I will ask you to give an introduction welcome speech, and you will turn on the microphone and get online.
Okay, clear.
Hello, everybody. It's Diego.
Hi, Diego. Hi, Diego.
Diego, hi.
Hi, Diego. Good
Buenos
morning.
días.
Buenos días.
Buenos días.
So in a minute we'll start. Okay.
Okay, ready.
Hello, everyone. Nice to see you online. My name is Arthur Nitsevych. I'm a partner of Interlegal law firm. This is an annual event run by Interlegal, and we are very excited that in 2020 and in 2021, this particular event is supported by INS law firm. Of course, we would be pleased to see all of you in Odessa or in Istanbul at our usual offline events in presence, especially because this year we have had a nice reason for seeing each other for festivities. Interlegal celebrated 25 years, but unfortunately this year again, we have to be online. We have to support each other, our clients and colleagues. So let's check up today what has happened during the last year, what updates we have faced from different corners of the world. Today we will have 10 great speakers on different topics. These are people that we know for many, many years. And I'm very glad that they agreed to share their views and experience today. Every day here at Interlegal, we have cases going on in different countries, in different parts of the world. And it is very important for us to bring information from the first hands. Special thanks to INS law firm, especially to Julian Clark and George Zambartas, our good friends. Your support is great. We really appreciate it. Without it would be impossible to have all the delegates at the screen today. George, can you give a short introduction speech to our delegates? Limassol, please take the baton.
Just going to hopefully make my video work. I'm having some technical issues making the video, but can you hear me at least?
We can hear you, yeah.
Well, it's better than seeing me anyway. So, good morning to everyone. INS is thrilled to be the exclusive sponsors at this year's Interlegal Online Shipping and Trade Day event. INS has a rich history in the maritime sector, and Cyprus is a hub of activity in the industry. I'm very pleased to be representing INS and our Cyprus office today, among many other key players and industry leaders in shipping and trade. I'm also delighted that Esther Dumpuri will be giving a presentation on the highly significant Eternal Bliss case. Having recently relocated back to Cyprus, Esther has previously worked in the INS London office, handling contentious and non-contentious maritime work, including court cases and London arbitrations governed by English law. Today's event will focus on how we can navigate the challenges of COVID-19 in our industry, how to be ready for trade and shipping industry challenges, and how to adapt to global changes. Throughout the day, we are really looking forward to hearing from a range of speakers who will discuss shipping, international trade, COVID-19, and the legal implications of those. Modern trends for dispute resolutions, what to expect with global challenges for international trade, and what the new era holds for shipping businesses. We hope you enjoy what is sure to be an informative and worthwhile event.
George, thank you very much. So, ladies and gents, we have about 200 people registered from 40 countries, and also we hope to have online after the end of the stream more. We have two streaming lines, one in Zoom and another one in YouTube. So please feel free to ask questions, to put some comments we will do our best to make it a little bit interactive today. Short introduction for Interlegal, a moment. Short introduction for Interlegal. Our key practices you can see on the screen: shipping, logistics, international trade, corporate taxes, and yachting. We are a Black Sea law firm. Our headquarters originally are in Odessa, in Ukraine, but we have set up during last 10 years our own offices in Georgia, Turkey, Bulgaria, Romania, and Moldova. Our so-called associated offices are around the world. This is a, let's say, best friends network. What does it give to our clients and colleagues? It gives an opportunity to have no entrance tickets, as we call, in any country of the world. And of course, this is all well connected to import and export routes for cargoes coming in and out of the Black Sea. You can see some key numbers, figures for Interlegal. I would like just to fix your attention on two of them. In Odessa now we have 60 people in our team. This is a good number of people that is ready to accept any instruction 24 hours per day. And also Interlegal is very known for its pro-commercial approach. We are keen to find a good amicable settlement between the parties, but in 70% of cases we are doing this way. But if we do not, if the situation does not allow it, then we are also good fighters and we can arrest a ship or release a ship if necessary. And my particular presentation today will be dedicated to ship arrest and release. So, okay, we can go on. And today, the first speaker, which who is all I think is ready, it's Grant Hunter. After Grant Hunter, we will have Grant Hunter from BIMCO. After Grant Hunter, we are following our schedule as every speaker will have some 15-20 minutes for the presentation, for questions and answers. The next speaker will be Daniella Horton, Maritime Arbitrator from London. Then Esther Tumpouris, partner of Ins law firm. Then we will pass the baton to Asia, to Thailand, to Nayaichon Tatong. Then a short presentation from me will follow. And after, we will have our headliners, our good friends, Alberto Battini from BTG Legal from Italy, Krzysztof Kowalczyk from BSJP from Poland, Diego de San Simon from Spain, San Simon and Duke, Larry Carvalho from Brazil, from Promare, and the final headliner, Big George Chalos from Chalos and Company from the US. So we are ready to start with the presentations. I'm passing the microphone to our first speaker, Grant Hunter. Grant, can you hear me? Can you turn on? The floor is yours.
I can hear you. Oh, it says I can't turn my video on because the host has stopped it. Are you able to switch my video on?
No.
Okay, I just get a message saying you can't start your video because the host has stopped it. Let me just see if I can share the screen instead then.
Okay.
Do you see the screen?
I think you need to allow panelists. Yes. Now you're online. Fine.
Okay, so you can see my screen. Okay, that's fine.
Yes.
That's better than just seeing me, although I carefully ironed a shirt especially, and I'm not going to get the benefit out of it. Okay, I'm the first speaker today. Thank you very much to Interlegal for inviting me along to speak today. What I'm going to be talking about is something that's a really, really hot topic in the industry, which is the carbon clauses. New legislation that's come out from the IMO, specifically amendments to MARPOL, which will come into force on the 1st of November 2022. So that's just 11 months ago, with the requirements to comply taking effect earliest the 1st of January 2023. So it's a really big issue for the industry because people are now fixing time charter parties that will cross that boundary into 2023, and they need something in their contracts to deal with this new regime that's going to look at various aspects of reducing carbon emissions in the shipping industry. So what I'm going to be looking at specifically today, move my slide on. First of all, there's 3 clauses that we are working on at the moment, one of which we've already published, which is the EEXI clause. We're also looking at CI, the carbon intensity indicator provisions coming out of MARPOL as well. And alongside that as well, there's a concern in the industry about the incoming or the impending European Union emissions trading scheme as well. And we may also see similar schemes coming out of other countries as well. So that's something else that we need to address, emissions trading systems as well. But these essentially are the 3 topics I want to look at in a little bit more detail today: EEXI, ETS, and CI. Lots of acronyms, but let's crack on anyway. So first of all, EEXI, the one-off case. I call it a one-off case because probably of all the clauses, this is the relatively easiest one to deal with, because it is primarily a case of complying with a certification requirement for the ship. It's a one-off certification. And you simply need to comply with it by the list on the 1st of January 2023. It's often get asked the question, what is EEXI? We're a great one from acronyms in the shipping industry. I wondered for a while what X stood for as well, but actually what EEXI stands for is Energy Efficiency Existing Ship Index. So it's designed for ships currently in operation, and it's essentially establishing, based on the performance criteria of the ship, how efficient that ship should be operating in the future. So you need to benchmark that, and that needs to be certified. And we'll go into detail how we're actually going to deal with that in a second, but essentially it's a one-off certification that needs to be done in the future. It's in many ways, as we enter this sort of low carbon regime in the future, it's the sort of entry into this program as well. You need this to get into the game. You need to do other things to stay in the game. So this is a very important element, but it's the starting point. And it may well require that some ships will need to change their speeds and consequent consumptions as a result of this. So it has a very important consequence for the shipping industry, and it's something we need to deal with contractually. The second one is the ETS scheme. So that's the emissions trading schemes that we're seeing around the world. The one that people tend to be fairly focused on is the European Union emissions trading scheme. I've called it trading with uncertainty because at the moment the legislation isn't entirely in place. We don't know exactly how it's going to work, but nevertheless we need to start putting things into our contracts to try to deal with it. So it is important. We don't know what the legislation is going to say. We can try to work out and try to allocate responsibilities amongst the parties about how that might work in practice, and so we need to make some decisions commercially about how that's going to work. What we've decided as an organization in BIMCO is that the principle we'll apply is that essentially the time charterers are the ones that conventionally pay for the fuel under a time charter party. It's the fuel that's emitting the carbon emissions, and therefore we want to make them responsible for the actual allowances that are issued by the European Union or other bodies in terms of trading and these carbon emissions. So we think it's perfectly reasonable that this is a cost that should be passed on to the charterers. We'll go into a little bit more detail when I talk about the clause as it currently stands, how this transfer of allowances would work, if the charterers have to acquire or obtain the allowances and it's the owners responsible for surrendering them. How is that process going to work? Because as we all know, allowances will fluctuate in price, and how do we control that pricing structure through the year when the allowances don't need to be surrendered until the following calendar year? So we need a mechanism for that in our charter parties. And then finally, the carbon intensity indicator, the CII, we call that the bit of the game changer. It is a very, very difficult thing for the industry to try to deal with. It is for us, BIMCO, the biggest challenge. There's no two ways about it. It's a very, very difficult thing to deal with indeed. You know, in many ways, whatever you think of the IMO and the legislation it comes up with every now and then, you may think this is a great piece of legislation. Of course, we have to comply with it as ship owners. There's no two ways around that. You might think this is a good bit of legislation, or you might think, what on earth were they thinking of when they came up with this? I was trying to think of sort of an analogy to sort of describe the sort of curious position we find ourselves in the shipping industry with this CII legislation. And I was thinking about the aspect, if you were, you know, perhaps to order a taxi to take you to the airport, you're a bit rushed to catch your flight, and you hop in the taxi and you say, you know, can you get to the airport as quickly as possible? And the taxi driver says, well, unfortunately, due to new emissions regulations, I'm only allowed to go at 50 kilometers per hour. That's my maximum speed. That's what I'm limited to. You just have to accept it. I mean, that is the legislation. That's what's imposed on you. You might arrive at the airport a bit late. You might miss your flight. You're not going to be very happy. But maybe next year, if you get into a taxi as well to also get to the airport, and you say now, okay, well, Mr. Taxi Driver, I understand that you're sort of working in a low carbon environment. You can only go at 50 kilometers per hour, but nevertheless, I've left a bit of time aside for doing that. And the taxi driver says, yeah, that was last year. This year, because I have to continuously improve and lower my carbon emissions, I'm only allowed to go at 40 kilometers an hour. I said, okay, well, this is not so good. And then he says, well, there's another restriction as well. I can't take all your luggage as well, because the extra weight will also increase my carbon emissions. So we're going to do a deal on the luggage as well. And he said, but one other way around is we could also go on a longer route to get to the airport. That would actually help me with my carbon rating. And you think, oh, this is a very strange solution to the industry. What are these things that we're going to have to do in order to meet compliance? How are the owners and the charterers going to resolve this commercially? Because the charterers need to have the services of the ship. They need to run efficient shipping operations. The owners need to help for competitive shipping and efficient shipping as well. We need some mechanism to resolve these strange anomalies that might come out of the legislation. We need to find a solution that's going to work for both parties. And essentially, that's all going to be down to cooperation and collaboration. That things are going to change in the industry in the way that we're going to have to operate ships, and perhaps some of the responsibilities that charters will have to take on that at the moment under a time charter party, they don't. So that's why I'm calling it a bit of a game changer. I think things will have to change a lot for this, for us to be able to comply with this legislation in the future. Let's look now a little bit more detail in the EEXI transition clause. Now, this is the first of the series of carbon clauses that BIMCO has published. We just published it a week or so ago. It's out there. People have seen it now, and we're pleased to see that we're getting some very positive and encouraging feedback on this clause. It's always difficult to find the right balance when you draft clauses like this, entering into very new territory. We want to produce things that are sort of fair and balanced and practical for the industry to be able to use. So the clause is out there now, and if you need a copy and want to see the guidance notes, they're available from BIMCO's website. Now, the first part of any of these clauses when we come to this new regulation is, again, coming back to this issue of sort of collaboration and cooperation. The parties need to accept that this is necessary. We have to do this as an industry. We have to go down this sort of reducing carbon emissions route. So you have to accept that things are going to need to be done to make shipping more efficient. And one of these things is that in order to comply for EEXI certification, some ships may well need to carry out physical modifications to reduce the power output to the ships. And that is a physical thing, something may need to be put on board to actually sort of govern the physical output of the ship. We believe that the most two common methods that are likely to be used for this are called EPL, which is engine power limitation, and shapley, which is shaft power limitation. So these are both physical things that are done to the ships to reduce this power, to place a cap on it that you can't go beyond when you're in normal operation. You can override for safety reasons, but in a normal commercial operation, you can't override it. We believe that these are going to be the most common ways of doing it. We also believe that, having spent the past few months looking into this, that in most cases, this work should be able to be done without interfering with the service of the vessel. The vessel shouldn't have to go off hire to do this work. It's a relatively simple process for it to be done. But again, it's all about communication and planning. So a lot of the clause is gearing up to the fact that, when is this going to be done? Talking to charterers where they plan to use the ship, where can this work be done? When will it actually take effect? So communication is a very, very important aspect of this. So say we're focusing on these two particular methods. We're not excluding other methods, but we just have to focus, for the purpose of keeping the clause relatively short and workable, what we think are the key methods. So the starting point is that if you're going to fit one of these methods, you need to tell the charterers in advance what exactly it is you're going to do, and give them an estimation of what this new maximum speed will be and what the consumption will be, because essentially we are just reducing the maximum speed of the ship. It may be in some cases that because of the warranted speeds you've given the charterers as owners, it may already be below the maximum speed of the ship, and therefore if we reduce the maximum speed by 0.5% or whatever in order to comply with the EXI, it won't have an impact on the actual warranties you've given the charterers. So that's something you need to think of as well. In that case, it's okay to have this clause in here. It won't trigger anything, but it's good to talk to your charterers and explain exactly what's going on. But in some cases, it will result in a reduction below the warranted speeds and consumptions. It is only the maximum warranted speed and the maximum consumption for ballast and laden speeds, but that you need to advise the charterers of, so they know in advance before we start all this work what they can expect, because they will need to accept this as the new regime, as the charter party progresses through the charter party period. So again, the clause is very much focused on communications. It's focused on planning this work to be done so that it doesn't impact on the charterer's use of the vessel, if at all possible. There may be circumstances where it's not possible, and the owners will have to perhaps put the ship into a dry dock or whatever, or perhaps he wants to do other work as well. Therefore, he has the right to do that. But and I say the primary focus is trying to keep this in service. But if the owner does take it out of service, then obviously he should be responsible not only for the cost of the modifications, but for any time loss that the charterer suffers. So this is not something we're passing entirely onto the charterers. It is very much an owner's responsibility. But once the work has been done, then it's very much a case that the charterers need to accept these new speed and consumption warranties. We're fairly confident that the estimates that would be made during the planning process are likely to be extremely accurate. So we're not expecting to see some great discrepancy when the work is actually done and the unit is actually switched on. So from that point of view, we expect no surprises. As long as you've communicated well with the charterer should know exactly what's happening. The work can be done at any time up until the point where you're actually legally required to put the EXI into effect and for the device to take effect and to reduce power limitation. So you can do the work at an earlier stage, and you can simply carry on trading at your normal power output until such times as you have to comply with the regulation, which will be on or after the 1st of January 2023 at any sort of annual or intermediate surveys immediately after that date. So it's not, all doesn't have to be done on the 1st of January 2023 for every ship. It will be spread out over a period of time based on when their annual surveys are due, and that's when the power limitation will take effect. But the charterer needs to know when that's going to happen, and you need to know the consequences of it. So the clause deals with all of those aspects in there, we think, in a fairly thorough and comprehensive way, so that there's no surprises for the parties. Now we've also had questions about, well, what happens if we want to fit other types of energy saving devices, and there are many out there at the moment, and many have been constantly developed. And BIMCO as an organization is very, very much in favor of innovation in shipping. We need to innovate to make more efficient ships, but we can't possibly prescribe what some of these things might be. So what we've done, we've left the clause open to the effect that if the parties do want to install some other energy saving device in addition to or as an alternative to EPL or shapley, then of course they can do that, but they need to sit down and talk about how that's going to be done. We can't prescribe for that, and we don't want to, but nor are we saying that it shouldn't be done. We're very keen for other innovations and other solutions. So the door is left open to that in the clause. So it has a degree of flexibility in that perspective. If we look now at the second clause that we're working on, this is the emissions trading scheme allowances clause, again for time charter parties. It is primarily focused on time charter parties because these are the ones that need to have something written into them now, because people are fixing for beyond the coming into force date of this expected legislation. So same with all the carbon clauses, we will develop other versions of these clauses for other types of contracts. These are the ones we're focusing on at the moment. So emissions trading scheme, really important to emphasize, we're not writing this just for the European Union ETS scheme. I know there's a big focus on that, but it's unlikely to be the only ETS scheme in operation in the world in the coming future. We do expect to see other similar ETS schemes coming along, and hopefully one day we'll have a global one. But in the interim period, we've got the EU one, and there are others, perhaps United States, perhaps China as well, coming online. So we want a clause that is generic enough to address all of those different ETS schemes, even though we don't have all of the information to hand to know exactly how they will work. And again, like everything in this new sort of carbon regime, this new low carbon world that we're working in, cooperation is absolutely fundamental between the contracting parties. And we've got to be able to exchange information for this to work. So, the owners have got to give emissions information to the charterers. They've got to have this information verified by external independent parties. But for the charterers as well, they need to give information to the owners to make sure that the owners know what they're actually going to be involved in terms of voyages and whatnot. So there's a two-way flow of information. We need transparency and we need cooperation in order for this to work effectively. So that's an important part of the clause, that we put something in there. As I said earlier on, our policy is and our principle is that the charterers are to provide and pay for these emissions allowances. They're the ones providing and paying for the fuel, so we think it sits very neatly alongside that they should also get these carbon emission allowances from whatever authorities. So it's a case of the charterers obtaining these for the voyages that they use. We haven't based the clause on a per voyage basis. That would be very convenient, but for a clause that needs to work across all different sectors of the industry, we need to determine exactly what a voyage is and how long that voyage is. A voyage in the container industry, for instance, isn't the same as a voyage in the bulk sector. I mean, a voyage in the container sector is, from right across the world on all the intermediate scheduled ports. So that doesn't really work very well to use that language. So essentially, we're going to work the clause on a monthly basis. That you have to submit the allowances on a monthly basis. You know what you've done in that previous month as a charter operating the ship. You'll be able to calculate what allowances are due, and that you would transfer those allowances to the owner so that the owner can gather those in his allowances account and then make the surrender of the allowances at the year end. The challenges for these ETS systems, it's not so you don't sort of pay as you go, it's an accumulative thing. The allowances are sort of aggregated over the year. You work out how much emissions you've made for the ship over a period of year, and then you surrender the necessary allowances in the following year when you sort of do your account. So it's slightly complex how we're going to do this. What happens if there's perhaps an overpayment of allowances or an underpayment or whatever? How are we going to deal with that? What happens if the ship goes off hire for whatever reason? How do we operate it? Now, we've made the principal decision that we're not going to base this on the cost of the allowances. We're not talking about handing over the value of the allowances to the owner. We will actually transfer the actual allowances. So therefore, if we do need to address an overpayment because of an off-hire, and the owner needs to send back or transfer the allowances back, it's not a cost, because the cost will fluctuate over time. People are trading allowances, the price will change. That makes for a very complicated clause. So if we simply talk about the allowances as being the currency, then you simply transfer whatever portion backwards and forwards in order to resolve any differences that may occur during the charter period. It's possible that it may be the owners or the charterers that can surrender allowances. It's really going to depend on the scheme and how that particular scheme works. So again, we need to put something in the clause that addresses that. It may not just be the owners alone that surrender the allowances. It may be the charterers allowed to do that. So we need some provision in the clause for this to happen. we need to address the situation. What happens if the charterers aren't the ones responsible for surrendering the allowances? It's the owners, but the charterers don't surrender the necessary allowances in time for the owners, to actually feel they're present at the possibility of should the owners be allowed to suspend the performance of the ship if that happens, because it's quite a serious impact on the owners and the future trading of the vessel if they don't surrender the necessary allowances, or if they're going to be out of pocket of having to pay the allowances themselves because the charterers haven't done that. So we needed some sort of commercial leverage in there in order to encourage the charterers to pay. And if it was the other way around as well, what happens if the owners fail to surrender at the year end, and as a result the ship is restricted in its trading ability because it hasn't surrendered the allowances? That has an impact on the charterer and his ability to trade the vessel. So there should be some indemnity in place to protect the charterer if the shoe is on the other foot. And also we need time to resolve this sort of thing. It can't just be an instantaneous transfer of allowances. The owners need to give the necessary data and the calculation they've used to come up with the requirement of the allowances to the charterers. We're thinking we'll give them 7 days to come up with that, 7 days for the charterers to be able to actually resolve that information and to acquire the necessary allowances and then transfer them to the owner. So we're given like a 14-day window in each monthly period for that transfer and for the calculation of allowances to happen. So there's a window there of opportunity for people to calculate what's necessary. So that is the emissions trading scheme. And I say we're working quite hard on that at the moment. We'd like to get this clause finalized and out to the industry by January next year. So, we do have a clause being worked on at the moment. It generates a lot of discussion, but hopefully we get that done by January next year, because I know it is very much in demand. Then the last one, the CII compliance clause. This is most definitely the most difficult one of all to tackle. We have started drafting work on it, but it is very, very complex indeed. We started by looking at, the scope of the clause. What does it need to include for this to be able to work? Obviously, defining what are the main terms, what is the legislation that applies, how you're actually going to operate this clause in practice. Again, the statement you will see again and again, owners and charterers to cooperate and share data. This is across the board with all of these carbon clauses. We need to see a sort of slight change of mindset in the way the industry operates, that we need much, much more cooperation and collaboration for this to work. And especially when it comes to CII, the owners cannot do this on their own. It's simply not possible. We need to work together with charterers to ensure compliance. We need to think about delivery and redelivery, that the ship will be delivered with a certain CII rating, the obligations on the parties to maintain that rating through the charter period, and what rating should it be redelivered with at the end. And maybe it starts with an A and B rating. Maybe you can agree it should be delivered with no less than a C rating at the end, or you should maintain that CII rating throughout. These are all things that we need to resolve. And indemnities as well. If the parties don't do what they do, we need to have indemnities in place to protect the parties. So all of these are factors we need to look at. Deviation and bills of lading. To comply with CII, you may need to, effectively slow steam the vessel, operate on a slower speed. You may need to look at more fuel efficient routes than perhaps the most direct routes. These will be considered as deviations, and they may have impacts on the third party bill of lading holders as well. So that needs to be taken account of in the clause. When it comes to the charterer's orders, if the charter gives an order that the owner say, well, if you do that, that's going to exceed my sort of carbon allowance for this month or this year, or whatever, should the owner have the right to refuse a charterer's order because he believes that particular voyage may impact on his carbon rating? We think not. I don't think we can go down that route. I think the parties need to work together and find out and plan together how they operate the ship. And I don't think it's reasonable that an owner should be able to refuse one order, because essentially the CI rating is an aggregate of the emissions over a period of a year. So one voyage may well exceed the sort of the range of that CI rating, but the next one might be much lower. So it might balance itself out over the period of the year. So therefore you can't reasonably refuse one particular voyage because you don't know what's going to happen to the rest of the year. But similarly, a charter may end halfway through a year, and then another charter starts. Well, if that first charter in the first half of a year uses a lot of those carbon emissions, it doesn't leave much for the second time charterer to use in his period. Again, we need to work out how do we resolve these things for fair and balanced ongoing trading, and it's only going to come through planning and cooperation and exchanging information. How is this going to work for shorter voyages or long-term charters as well? We need to find a contractual solution that works for both. So again, it's quite difficult to know how this is going to operate in practice. And then we come to the Enhance the Ship's Energy Efficient Management Plan. The charterers simply have to acknowledge in this new world that the owner is not under an obligation that annually he has to improve the efficiency of the vessel. And therefore, the margins in which he's able to operate in terms of maintaining a C rating will get narrower by 2% every single year, right through to 2026. The charters have to accept that. So it's going to make operations much, much more difficult. So, the sort of bandwidth being able to operate the vessel and what they could do in the past for the vessel is going to be restricted. And that needs to be taken account of in the charter party as we move ahead. We don't know what's going to happen beyond 2026 at the moment. We know that the margins will narrow by 2% every year. At the moment, there are not even any sanctions in place for non-compliance with CI. That will be talked about for 2026 and beyond. But at the moment, this is an unusual piece of legislation. There are no sanctions for non-compliance, and we don't exactly know what's going to happen in the future. We can only plan up to 2026. But at this narrow corridor, a corridor that gets ever narrower because of the obligation on the ship owner to constantly improve or continuously improve the efficiency of the vessel over time. It's nothing we've never seen anything like this before at all. So it's very, very unusual indeed. So every year we've got to sort of have this management plan. It's got to be agreed to by the parties. You've got to work together. We've got to make sure that compliance happens. And it's the sharing of information, and it's almost as in the future, the charter is going to have to accept in some ways responsibilities for the maintenance of the ship in some ways. It's something that's always been the domain of the owners. I think we're going to have to start to see changes in our charter parties that are going to have a direct impact on the responsibilities and the obligations of the charterers. And I think that's essentially the only way it's going to work. We need to see these sort of real changes in the way that the ships are operated. And I think as well, accepting the fact that, over time, the terms and conditions and the warranties under the charter party are going to change. They're not fixed for the entire duration of the charter party anymore. They will alter over time. And again, that's a new concept for the industry, something that needs to be addressed in the clause. So you can see this is a very complex thing to deal with contractually. We're doing our best to sit down and try to work out how it'll all work. And we are working together very closely, not only with ship owners but with charterers as well, because they need to have their input into all this. They need to accept how this needs to work in practice. It's perhaps easier to do with some of the larger charterers who obviously have their social and corporate obligations as well to reduce carbon, so they need to buy into this process as well. So it's difficult to see how it will work in practice. We are very encouraged with the feedback we're getting that we can find a solution to this, but we'll just need to see. So we're working very hard on this, and we hope to find a solution and have a contract or have a clause in place by February next year. That's our sort of target for getting this completed. So just to move to the end here, just to recap then, as my time is up here, the three clauses that we're working on, the AXI, it's the one-off case, the certification for the ship's energy efficiency that needs to be established and put in place, possibly with physical modifications. That clause is out there now, and it's available to use immediately, and we would encourage you to put it into your time charter parties. Emissions trading schemes, looking at the EU, but also looking at other schemes as well. We don't have all the answers in place because the legislation is not yet finalized, but we do need to see something going into charter parties. We're actively working on a clause for that, and it will essentially be the charterers that are responsible for obtaining allowances and transferring those to the owners to make sure that the owners can meet their emissions obligations there. And then finally, the CII, the carbon intensity indicator, very, very challenging indeed for the industry, but we are working very hard to come up with a solution for that. Are these workable solutions for the industry? Certainly we believe, as far as EEXI is concerned, that yes, we have come up with something that is very workable, but let's say, relatively speaking, that was the easiest one to resolve. The legislation is sometimes difficult to transfer and distill into something that's going to work commercially, but that is our focus as an organization. Where we see ourselves as the practical voice of shipping, coming up with practical commercial solutions, and that is what we're going to do with the ETS allowances clause and also the CII. Try to come up with a practical solution that's going to be workable and acceptable to both parties and will work in the real world. Thank you very much for that.
Grant, thank you very much, Grant, for your presentation. Grant is BIMCO's head of contracts and clauses, responsible for development, revision, and promotion of different clauses and standard contracts. Grant, you are in the industry for 40 years. I have a question. This topic looks challenging, if not revolutionary, I would say. And of course, there is lack of information on its consequences. I would say at our end of the world, here we even cannot understand, let's say, all consequences and all serious provisions of this topic. What do you think? How much time is needed to get better understanding in general for everyone engaged in shipping? What countries will be, or in what parts of the world the headliners will be? Yes, who is going to develop this topic first of all?
Yeah, I mean, from my perspective, I mean, this is a real wake-up call for the industry. I mean, it surprises me sometimes. We were sort of, started to look at this earlier this year, and we're thinking, the industry really needs to start switching onto this and really focusing on this, because there really isn't very much time to get in place. As I say, I mean, essentially, we've got a year before this takes effect and these regimes start to have an effect on the industry. And I think absolutely everyone needs to start focusing on this absolutely immediately. It's really, really hard to tell how this is all going to play out in practice, because it's simply something we've never seen before. This idea with CI, sort of the concept of continuous improvement of a vessel, where essentially we're going to have to make the vessel more efficient every year in order to maintain the CII rating. How does that play out in practice? What does it mean for a charterer who's reliant on transportation services to take a ship that, the way it needs to be operated is going to be different from year to year? He's going to have less leeway in the way it needs to be operated. I mean, what we don't want to find out is that, ships, yes, the obvious thing to reduce carbon emissions is to reduce speed slightly. We don't want to see some of the other options, like sort of, shutting out cargo. That doesn't really help people. Reducing speed and shutting out cargo essentially means you would still need more ships. It would increase the demand for shipping. So is that a good way of reducing carbon emissions? Probably not. So I don't know how the shipping industry will develop and the movement of goods around the world will develop in response to this, but it is something that everybody really needs to sit down and look at and talk about. Because we certainly do not have all the answers to this at all. And we need this dialogue, and we need conferences like this where people sort of open up and talk about it and try to work through what are all the problems, what are the possible solutions, what are the scenarios we may be facing here. So no, we don't certainly have all the answers, but we need to start talking about it, as much as we can from the commercial perspective. How do we make it work from a practical and commercial perspective in the future?
So probably the best way is, yes, to spread this information, to share this information much, and then in some, let's say, in some a period of time, in a year or so, probably we will have more feedback from the industry on that. So let's focus. Yes, let's focus on start talking on that more and more.
No, absolutely, yeah, and when it comes into force, we are going to learn a lot just in this first year or so of implementing.
It looks like a really new reality. Yeah.
Yeah, definitely.
Grant, thank you very much for your presentation, and special thanks to BIMCO, which supports our events all the time. Thank you very much.
Thank you.
The next speaker is Daniella Horton. Daniella Horton is our good friend and colleague, Maritime Arbitrator, ex Honorary Secretary of London Maritime Arbitrators Association. Again, unfortunately, we cannot see you, Daniella, offline in Odessa or in Istanbul, but it's a pleasure to have you as a speaker again on our online event.
Arthur, thank you very, very much. Needless to say, I very much look forward to joining you there one day again. But as you say, for this year, we're online again. Let me share my screen with you, and then I can share some of the news that I have from London.
You are online. Thank you. Come on.
Super. Thank you. So first of all, it's a great pleasure to have this opportunity again to talk to your Shipping and Trade Day audience. So good morning, everyone. Всем добрый день. And so what is the news from London in the last year since I spoke to you last? So I've identified 3 items of news that I'd like to share with you. Firstly, I'm going to update you on the use of virtual hearings, which is what I spoke about last year. I'm going to talk to you very briefly about the new LMAA procedural rules. And then I'm going to mention the expanding LMAA dispute resolution toolkit. So firstly then, a brief recap on where we were when we spoke last. So in terms of virtual hearings, looking back at my notes from last year, I was really struck by just how far and how fast things have moved from what last year was very much a new normal, a new thing for us. And yet virtual hearings, webinars, etc., are very much now the norm. They're the usual thing. So where were we a year ago? A year ago, most of the courts that had looked at the question of virtual hearings had confirmed their validity, as it were. So in other words, most courts were happy that virtual hearings were a legal alternative to an in-person hearing. In terms of the arbitration bodies, now not everybody needed a change of rules, but where necessary, the various arbitration bodies changed their procedural rules to either make it clear or to make it that a virtual hearing entitlement satisfied what was needed by their rules. And then, of course, by the end of last year, there was a myriad of technical platforms of support and guidance and guidelines. In London, that seemed very much to settle in terms of platforms into either Zoom or Microsoft Teams. And in terms of guidance, that many bodies produced different versions of guidelines. But I would commend to you the LMAA guidelines. I've set out a link there for you. And irrespective of whether you're thinking of an arbitration under LMAA terms or otherwise, I would encourage you to take a look at the LMAA guidelines. They were very well received at the time. They were one of the first that were produced earlier in 2020. And they're very much intended to be flexible, adaptable, and they are very deliberately practical. And so, as I say, I commend them to you if you find yourself preparing for an oral hearing. So at this point, I'm just going to very quickly look back. This was my last slide of last year. What were my predictions for 2021? So in brief, I very much took the view that virtual hearings would continue to be part of the arbitration landscape, but possibly as a matter of choice rather than necessity. I think it was foreseen that hybrid or semi-virtual hearings, so that's where, for example, you might have the tribunal in the room, everyone else online, you might have the tribunal and perhaps the advocates, and then others, witnesses, etc. online. Those were already becoming popular last year. And then also there was a possibility that this might increase the number of hearings overall. So what was the reality for 2021? So the clear message from the feedback we received, and that's both received by the LMAA, received generally by the industry, is that remote hearings were a very welcome addition to the arbitration landscape. Thanks to increasingly sophisticated technology, which, let's face it, very few of us had even encountered just 2 years ago. What we found is that virtual hearings, as I say, they've become the norm, or either virtual or semi-virtual have become the norm. They run smoothly, they run efficiently, and likely more cheaply than in-person equivalents. What we've seen, perhaps to the surprise of some people, is even once we could go back to in-person hearings, there has actually been an active preference for fully virtual hearings by some, which has been very well received. I think what is fair to say is that the most common form of hearings that we've seen this year, once in-person hearings were allowed again and we were unlocked from our restrictions, was some form of hybrid hearing. Now, as to whether this has increased numbers of hearings overall, we don't have the data for that yet. But what we can say, absolutely with certainty, is that without those virtual hearing abilities, there would have been substantial delays and backlogs. And so from London, we're very pleased to be able to say that we've been able to avoid that. So just very briefly then, the positives of virtual hearings, that they are flexible, they are efficient, they offer savings. And one of the most important things I think we felt, a little bit like webinars, is that it allows a much greater accessibility to be able to observe the hearing. So people who wouldn't necessarily have traveled to the hearing are able to view it. So that's the update on virtual hearings. So next, I'm just going to look briefly at the LMAA Terms and Procedures 2021. So ever since introducing the LMAA terms back in the 1980s, the LMAA's procedural rules have been looked at regularly. They have been expanded to incorporate the 3 sets of procedural rules we know today, those being the terms, the intermediate claims procedure, and the small claims procedure. And together they cover the gamut of large, small, and medium-sized claims. In recent years, it's become a practice that there's almost a regular 4 to 5 year review of the terms and procedures. And so last year, that formed part of that regular review. So on the one hand, you could describe the changes between the 2017 terms and 2021 terms as a fine-tuning exercise. But what I would say is that nevertheless, there were some important developments which were included in those amendments, those changes. And I've highlighted 3 here for you. Firstly, the virtual hearing guidelines were actually incorporated into the LMAA terms, and they became the 6th schedule to the LMAA terms, very much concreting virtual hearings into, as I said, our London arbitration landscape. Secondly, the new terms expressly incorporate guidance on the content of witness statements. Now, this isn't anything new, but really it's there to form a reminder of what witness statements should be and what they shouldn't be. So very briefly, that insofar as possible, the witness evidence should be in the witness's own words, that the evidence should be limited to the points where the witness evidence is needed to either explain the documents, fill the gaps, and so on. And what it shouldn't do is argue the case. That's for the lawyers. So that's a reminder as to what witness statements should and shouldn't be. And then thirdly, there was an expansion of the LMAA's appointing authority power. And this was to cover the situation where if an arbitrator had to retire due to ill health and a replacement was needed urgently, for example, for an upcoming hearing, rather than having to go to the court, which is the appointing authority without express powers given to the LMAA. This express power gives the LMAA the opportunity to step in and assist should that ever be needed. To the best of my knowledge, this hasn't yet been used, but the possibility is there if it were needed. So that's what I want to say about the LMA terms and procedures. As always, you can find full details of the text of those 3 sets of procedural rules on the LMA website. And there are also guidance notes to guide you through what has changed from 2017 to 2021. So lastly, my third item of news from London is an expanding of the LMAA dispute resolution toolkit. So needless to say, arbitration has, and I'm sure always will be, the mainstay of the service which the LMAA provides to the maritime industry. That's, as you know, we were set up in 1960, and today we estimate that 80 to 90% of all maritime arbitrations worldwide are conducted under LMAA terms and procedures. But we do have other services which we offer, and that toolkit of dispute resolution services is expanding. So for those of you who are familiar, the LMAA introduced mediation terms back in the early 2000s now. So they have been there for some time, and they're available for use if needed. More recently, last year, the LMAA added details of the use of adjudication and dispute resolution boards. Now, these are traditionally known for use in construction projects, and we are increasingly seeing their use in maritime-related construction projects. And so you'll find the page on the website. It's a reminder, if you like, of the service that the LMAA arbitrators and adjudicators can offer in that realm. The new addition to the toolkit I'd like to talk to you very briefly about today is early neutral evaluation. This is not yet launched, so this is very much hot off the press, new news, and it may be that in time you'll remember you heard it here first. So what is early neutral evaluation? So very briefly, it's a form of dispute resolution which is becoming increasingly popular amongst maritime parties. It's a form of determination by a third party, an evaluator, and it's a determination rather than a solution that's arrived at by the parties, for example, such as mediation. Now, ENE is likely to be non-binding unless the parties agree otherwise. And this is in contrast to expert determination, which tends to be binding on the parties. And this very much reflects what we understand to be the market sentiment, that they would like to have, if you like, a steer on their case, on the merits of their case, but not necessarily wanting to be bound by it. So I've set out there the objective of early neutral evaluation, and that is to give parties a realistic indication of the merits of their respective cases, as the name suggests, at an early stage in proceedings to try and avoid substantial costs that might follow if legal proceedings, arbitration, etc. are needed. And it's there to inform negotiations between the parties. So this isn't intended to be, it's certainly not intended to replace arbitration. It's not a panacea for all disputes. It won't be suitable for all types of disputes, and it won't necessarily always provide a solution. But what we're hoping and what we anticipate is in the realm of commercial shipping parties who already are used to thinking about negotiations, settlement, if they can, it's anticipated that in hopefully many, but certainly a number of cases, that early neutral evaluation will offer the parties a steer in the right direction which might in turn facilitate early settlement. So that's the news from London. Thank you very much. Spasiba.
Daniela, thank you very much. Good news from London. I got a question. What is the success story of being so flexible? I mean, from the LMAA side. We all know that this is not an institutional arbitration body. But I'm really pleased to see, for example, this E&E development, because this is so, let's say, so coming to the needs of the industry. So, what is the success story? Who is inventing all this?
Well, I think it's fair to say that although the LMAA is perhaps seen as a very traditional part of the arbitration landscape, the LMAA is also likes to be light-footed to pay attention to the industry and what we need. As you may know, we have a number of liaison committees that the LMAA committee works with during the year. And so we actively look for feedback and then act upon it. And this is something, in a way, for those who are familiar with LMAA arbitration over the years, if you go back to its very roots, it was perhaps a little more, it would be shorter, less legal, let's say. It was very much commercial arbitration at its heart. Now, over the years, inevitably, international arbitration has become more legal, and that can't change. We can't roll back the clock on that. But it seems to me that this early neutral evaluation may well offer, if you like, to plug the gap between what was maybe 60, 70 years ago and what we have now in terms of arbitration, so that there's an opportunity to assess the case at an early stage. As I say, it won't happen or it won't assist in every case. It won't be suitable in every case. But the feedback we're receiving is that there is an appetite for it.
Daniela, thank you very much for your presentation and bravo for your answer. Thank you very much. Really appreciate. We really appreciate your support on the time during, and hopefully we will see each other finally next year in presence.
I very much hope so. Thank you very much.
Thank you. The floor is passed to Esther Tompouris, Inns law firm. Esther is a dispute resolution lawyer specializing in dry and wet shipping in international trade and commodities. She advises clients on broad spectrum of disputes arising from charter parties, shipping contracts, contracts of affreightment, bills of lading, pool agreements, shipbuilding contracts, sale and purchase agreements. Esther, the floor is yours. You can turn on your video, or you did it, okay. Or you can share the screen. It relates to all speakers. We gave a permission to turn on the video too.
Okay.
Yes,
can you hear me?
Come on. Yes, we can hear you.
Great.
Come on.
Thank you very much for having me. And you can see my screen as well now, can you?
Yes, we can.
Okay,
we can see.
That's great. So thank you very much. I will be talking about the latest decision in the Eternal Bliss by the Court of Appeal and the impact that this will have in the type of damages that can now be claimed following a delay. And this is an issue that has vexed lawyers and legal commentators for a very long time. What can owners recover following a delay in a loading or a discharge port? And is there anything to be recovered over and above demurrage? So firstly, I always like to have a look at the vessel when I'm considering a decision. So for those of you who think in the same way, here is the Eternal Bliss. And by way of background, the dispute arose in relation to the carriage of cargo of soybeans from Brazil to China. At the discharge port, the vessel was kept at anchorage for 31 days due to port congestion and the lack of storage ashore for the cargo. As a result of the delay, as expected, the cargo suffered significant molding and caking, and the receivers brought a claim against the owners, which was settled for $1.1 million. Owners, as expected again, commenced arbitration against charterers, seeking damages or an indemnity in respect of the amount that was paid. And charterers obviously claimed that the demurrage was the owner's exclusive remedy for their delay. The demurrage clause in the charter party was a standard one, as you can see here. So it just stated the demurrage, if incurred, to be declared by owners upon vessel nomination, but maximum $20,000 per day pro rata, dispatch half demurrage late time saved at both ends. So to start with, the parties agreed that a question of law would be referred to the commercial court in aid of the arbitration, and that was done pursuant to Section 45 of the Arbitration Act 1996. And basically the question for the court, as you can see here, was where a vessel has been delayed at the discharge port beyond the agreed lay time, and that delay has caused damage and loss for the owners, is demurrage their exclusive remedy, or are the owners entitled to recover, in addition to demurrage, damages for the charter's breach, or an indemnity in respect of that loss for complying with the charter's orders? And was it necessary to show a separate breach in order to recover damages over and above demurrage? I should mention that it was common ground between the parties that the only breach committed by the charterers was the breach of their obligation to discharge within the agreed lay time. And the assumed facts for the court were that there was no causation or remoteness issues in respect of the cargo claim. That is to say, there was no break in the chain of causation, and the type of loss was within the reasonable contemplation of the parties at the time they entered into the charter party. So the owners argued that where the charter's breach causes damage over and above detention, then they should be entitled to recover those losses. And the charterers were arguing that demurrage should be their exclusive remedy. So the judge in the first instance considered all the relevant case law and prepared this grid you see here on the slide, which formed part of the judgment. And basically what he sought to do was to kind of classify the different cases dealing with the two main questions, which were, as you see on the top, was there any other claim other than detention? And then on the left, was there a separate breach? So if the answer to both questions is yes, then the cases pointed to the fact that there would be a possible recovery. If the answer to both was no, obviously there's no recovery possible. And then if there is a separate breach, but no other claim, obviously, again, no recovery possible as per the top right quadrant. But what was the subject matter of this case was the bottom left quadrant. So what happens if there is another claim other than detention, but there's no separate breach? So in essence, the question for the court was this. So is this the correct equation? Do you need a separate type of loss and a separate breach in order to recover the damages? So in order to reach the decision, the judge had to consider what does demurrage liquidate? And having reviewed all the previous case law and the leading textbooks and the commentator comments, decided that demurrage simply compensates owners for the loss of use of the vessel to earn freight due to the delay and nothing else. Therefore, all that was needed for the owners was to show that there was a different type of loss, but there was no need for them to show that there was a separate breach by the charterers under the charter party. So going back to my equation, in the first instance, the commercial court decided that a separate breach was not necessary. All they had to do was to show this separate type of loss. And of course, that was a very welcome decision by the owners. And we did at the time see a great number of inquiries from owners about what kind of types of losses in addition to marriage can be claimed, and could we rely on the eternal bliss to bring a number of claims against chargers. But of course, this was short-lived, as the decision was soon appealed, as expected. And the appeal raised the point on which really there was no previous binding authority, and which had for almost 100 years divided eminent judges and commentators. And so the Court of Appeal reviewed all the case law on the matter, and as expected, concluded that the cases were inconclusive. So the Court of Appeal considered that when the parties agree a demarriage clause, the parties would probably primarily be contemplating loss of prospective earnings, which would be suffered as a result of the charger's breach. But the Court of Appeal ruled that this did not mean that demarriage should be limited to that. So the Court of Appeal decided to give a much broader scope of the meaning of demarriage, and instead concluded that in the absence of any contraindication in the charter party, the demarriage liquidates the whole of the damages arising from the charter's breach. Therefore, if an owner wanted to recover anything and above that, they had to show a separate and distinct breach under the charter. And the court gave a number of reasons for its decision, but one of which I think was given a lot of weight was they thought that this would give clarity and certainty for the contracting parties, and left it with them to stipulate a different result in the charter parties if they wanted to depart from this. So going back to my equation, the Court of Appeal brought back the second element here. So you need a separate type of loss and a separate breach in order to recover the damages. So where do the parties go from here? This may not be the last word on the issue, as there may be a further appeal to the Supreme Court. And as you may know, there's been a lot of discussions on this decision, so it wouldn't surprise me if this ended up with the Supreme Court. However, on the basis of the current decision, it is clear that owners will not be able to recover anything other than the agreed demarriage unless there is a separate breach. And of course, that is of importance to the owners and the parties in general, because there are a number of different types of losses that may arise following a delay at a loading or a discharge port. So for example, we see here cargo claims, hull fouling, changes to the bunker prices, additional supplies in stores, crew change costs, port charges, and anchorage dues. So an array of different costs that would somehow need to be allocated between the parties. So how can the parties deal with these? It was clear from the Court of Appeal's decision that if the parties wished for any additional losses to be recovered, then this would have to be catered specifically in the charter. So one option would be for the parties to specify that the demarriage will only cover specific losses. So specific losses or items. For example, the clause could say that this would only include lost time, port and bunker costs. Or alternatively, it could exclude certain types of losses and, for example, say that the marriage covers everything other than cargo claims, for example. Another option would be to ensure that the demarriage rate is sufficient to cover all possible losses that would arise following the charter's failure to load or discharge within an agreed late time. But again, that is obviously a very difficult thing to do. So many unknowns when trying to figure out the demarriage rate. Of course, the ability to make any such amendments, so to either specify specific losses or exclude some of them, will depend on the market and who has the upper hand in the negotiations when the charter is concluded. But it remains to be seen if the matter will be referred to the Supreme Court and if this will change. But for the moment, it seems that this issue has now been settled. That's it. Thank you for your time.
Esther, thank you very much. It looks like a very good case point. Yes, and you gave very good practicalities and recommendations what to do next with it. Thank you very much. Please, probably it's something that I would like to ask you about Cyprus. So as far as I understand, you now work both in London and in Cyprus. How is Cyprus now, and how is Cyprus shipping now? We all miss Cyprus. Unfortunately, there is lack of traveling. There are restrictions. What's going to be next year? What are your hopes?
Well, at the moment it's very rainy here in Cyprus, unfortunately. But
rainy.
Yes, no sun today, unfortunately. But I think Cyprus is doing quite well. Yes, I'm operating and servicing our local and foreign clients from the Cyprus office now. And as you know, the shipping community and the shipping hub here in Cyprus is getting bigger and bigger. And we had a lot of feedback from our local clients saying they would like some English law capability coming out of our Cypriot office as well, which is why I'm now part of this office. And we see a lot more demand for English law advice from this jurisdiction, and a lot more shipping firms and ship management firms deciding to relocate here, as well as P&I clubs. So we're hoping that it's only going to get bigger and bigger for the shipping hub here in Cyprus.
Thank you. Unfortunately, in October, we missed an opportunity to come and have joint reception for our clients, and as we used to be for many years. Hopefully next year, Maritime Cyprus conference will be held next year, and we'll see each other in presence.
Yeah, hopefully that will go ahead next year. Yeah, it'll be good to meet you all in person.
Yeah, thank you very much, Esther.
Thank you.
The next speaker is from Asia, so we are coming around the globe. This is Nayachon Tatong, managing partner of JTJB. He's been appointed as managing partner of this law firm more than 6 years ago. His practice is focused on litigation, but he's got a rich practice in handling both contentious and non-contentious matters as well. The floor is yours.
Thank you, and hi everyone. For my issues on my topic is the force majeure from the pandemic disruption right and liabilities. The cloud of the situation, the recent and ongoing the COVID outbreak now, together with the measure many countries are adopting to bring the pandemic under the control, are creating the significant impediment to transport system and supply chain, which are facing unprecedented challenging on the global scale, which also affect to the shipping business. And for the shipping business, it have the related to the many parties. For example, the ship owners, the charterers, the shipper, the consignee, the buyer from international trade, and the various action taken by the government in some country to tackle the COVID situation is significant impact to all of them, because they might have the effect from such measure or such policy from the government. In Asia and in Thailand, we also have the some of the issue coming up from the COVID situation. For example, on the some on the some situation, once the number of the COVID patient is increasing higher, the government might have the lockdown, and it also affect to transportation, including the maritime and to the port of Thailand, and some of the countries is also have the same situation. Therefore, we have to concern with the COVID situation and the pandemic situation, which might or might not be comply with the force majeure clause. I would like to say that the affected party from the force majeure or from the COVID situation have to consider that whether their contract make the provision for the force majeure clause or not, and whether the COVID outbreak fall within the protection offered by the relevant clause of the force majeure or not. The force majeure events are broadly to speaking unexpected circumstance outside of the contractual parties' reasonable control that having a license prevent from performing the obligation of the contract. The release from the performance as a result of the force majeure is not recognized as the standalone principle of the whether English law, common law, or whether in the Thai law, which with the concept of the Thai law and the English law is a bit different on the interpretation of the force majeure. I will provide the example situation to talk about on the interpretation of the force majeure. Under the, as I understand of the under the English law or the common law, the force majeure clause when the affected party shall under the force majeure clause, they have to prove or rely on the condition that the situation or the circumstance is the force majeure or not. The affected party were prevented, hindered, or delayed from performing due to the force majeure event, and non-performance as per the contract is due to circumstance beyond the affected party control, and also there are no reasonable steps that the affected party could have taken to avoid or mitigate the event or its consequence. But the causation link test required with the English law or common law is have a bit different from the Thai law. We provide example from the Thai law because of because of the interpretation it from the civil law it might be different from the common law. Under the Thai law, we have the article to make the interpretation of the force majeure in the Thai Civil and Commercial Code. Article 8 is stipulated that the force majeure event means any event which is happening resulting in adverse effect which is beyond control despite the affected party being or damaged through for the delay or the it's beyond the control despite the affected party being or to perform the obligation of the contract. If you see on the term of the Thai law is on the civil law rules, it might a bit different because of the causation link test is lower requirement than the common law. The test of the common law is a bit higher because of the on the Thai law. Whenever the situation is foreseen or unforeseeable, it might be under the force majeure event. But if you see that in the common law, in case of the affected party can see or seeable of the such situation, it might not be the force majeure event. Why we talk about this? Because of, I think, of the COVID situation now, it's different from the previous year. Now the COVID situation in some country or in many situations, we can, or the party can see that what will continue, what will going on. If the party can see that it might interpret that such event is the foreseen event, is not the unforeseen event, and it might affect to the interpretation of the force majeure under the contract. I would like to provide the example from the situation of the force majeure. I have the sample case which related the ship owners, the charterers, and the shippers. The charterer charter the vessel, charter the time charter the vessel from the ship owners, which means the ship owner shall provide the crew and shall manage the ship. However, the charterer have another contract with the shipper to loading the goods to the vessels. Once the schedule or the lay time can fit between all three parties, and the vessel land to the loading port during the production or during the loading. At that time, the government of the loading port have the policy or the measure to lock down, which also affect to all activity in the loading port, which means everything shall be stopped. For such situation, the problem or will affect first to the ship owners because of the production cannot completely load. Therefore, it will have the demurrage cost occurred to the vessels. But at that time, the shipper declared the force majeure to the charterers, and the charterers also declared the force majeure to the ship owners. In such situation, which means that the ship owners cannot request or cannot enforce the charterer to pay the demurrage during the stop period occurred by the government on the lockdown situation, which means the losing party or the damaged party will be the ship owners. In such situation, it may be different if the contact between the party did not mention that the COVID situation will be covered into the force majeure clause if the government or the situation is occurred now, because of some situation it might be, or some situation might be deemed that the shipper or the charterer shall have to see what will continue on or what going on the situation, because of you have to know that now the COVID situation might be occur. The number of the increasing might be increased every day or reduced every day, which mean that it might be the situation that the COVID situation is not the foreseeable. Oh, sorry, it's not the unforeseeable, which means it might not comply with the condition of the force majeure. In such circumstance, I would like to say that in the COVID situation, because of the party related to the contract, might be over 2 parties, might be 3 or 4 parties. At least 1 party shall have to lose from the damage occurred from the situation, whether the force majeure event can comply or cannot comply with the agreement or with the contract between the party or not. We will not see the situation of the win-win situation to all parties, because at least 1 party shall bear the cost, except all parties understand or understood in the situation and come back to talk about it and settle it with the fair and reasonable ground to subsidize, to share on the subsidized cost occurred from such situation. But I think in the real world, it's not easy to happen, because of once the client come to talk with the lawyers, all the lawyer side will have to stand on the position that this situation is the force majeure or not force majeure event. Situation, our client or such client have to bear the cost or not. Therefore, I have to conclude that on the situation of the COVID now, it might affect whenever it will be the force majeure event or not, because of at least 1 party shall affected and shall lose from such situation. Thank you.
Thank you very much. Thank you very much. Very nice input and very nice examples of force majeure, different treatment of force majeure by common law and continental law. From our side, we have a number of cases here with same issues. Thank you very much for your support. This is your second talk, Nachon. And we really appreciate your support, and hopefully next year you also will be online together with us. Thank you very much.
Thank you.
The next speaker is me, Artnur Nitsevych. Let me start. Let me start my topic. I'm going to have a very brief presentation related to ship arrest and release in Black Sea countries. As you see, there are 7 countries all over the Black Sea. And I'm not going into details, into procedural details of every country. My idea is to give you today a snapshot what is similar in all these countries, because we usually have a look at the Black Sea countries. You see that there is only one end, let's say, ships that come into the Black Sea usually have trade here for some time, and usually ships are under the risk to be arrested in any country of the Black Sea. All these countries, people here have same mentality, and probably we can conclude that even similar legal regime. This is explained probably by the fact that the majority of the Black Sea countries have come out from the Soviet Union camp. This relates to Georgia, Russia, Ukraine, Moldova, Romania, and Bulgaria. And correspondingly, the paperwork regime, paperwork requirements also look very similar. We have prepared a map, let's say a few slides with so-called frequently asked questions. I'm going to have a stop only on those which are blue, because this is what we are asked usually by clients and colleagues. So as you see, the regulations are mostly same. It's either Convention 1952 or Convention 1999 being signed by the state or implemented into the local legislation. The period of arrest or period of provisional arrest looks also very similar, being 30 days in Ukraine, Turkey, and Bulgaria, 20 days in Romania, and only Georgia gives a very short period of time, 10 days. And it's, I would say that it's not easy to pass the case on the merits, for example, to London during these 10 days. Counter security, it's the next question, and you will see that almost in all countries, in all cases, this question is resolved at the judge discretion. In Romania, in Georgia, and in Bulgaria, there are, let's say, certain limit points, something like up to 20% of the claimed amount. In Ukraine and Russia, it's solely on at the judge discretion to decide what amount of counter security is to be presented. While in Turkey, this is a fixed fee, 10,000 SDR, which corresponds something to $14,000 US at the moment. And I can hardly remember cases when this amount was increased or decreased. The next slide is dedicated to security, and this is a question which is asked by P&I clubs on and on. As you see, P&I letter of undertaking is not accepted universally as a form of security. In Bulgaria, for example, it is clear that Bulgarian law does not regulate P&I letter of undertaking as a form of security at all. But in other countries, we can make a conclusion that P&I letter of undertaking can be accepted as security, but probably only in case the creditor itself agrees on that. Otherwise, we can make a conclusion that only a local bank guarantee or deposit can be secured and is accepted by the court as a security. How to appeal? How to make a release of a vessel? To answer this particular question, we can say that there are two ways. Generally, there are two ways. So either one has to apply to the very court which took a decision to arrest her, or the vessel can be released by the order of the Court of Appeal. Of course, it's subject to procedural rules, to procedural periods of time, which is necessary to make an application. But you see that in, for example, in Ukraine and in Georgia and in Russia, even the legislative norms, they even look the same. They sound the same. And one more slide is related to documents to be presented for an arrest. You will see that in Ukraine, in Romania, and in Bulgaria, it's quite easy to provide the powers to local lawyers. It's enough to have a kind of engagement letter. In Romania or in Bulgaria. In Ukraine, it is called a special document. It is called an advocate's warrant. While in Georgia, in Turkey, in Russia, rules are more strict, and courts require originals or notarized copies. But generally, I would say that again, these all Black Sea countries are quite friendly for preparation of documents for arresting a vessel. And probably last but not the least, it's a question of jurisdiction of over the claim on merits. You will see that Romania and Bulgaria say no to that question. Bulgarian and Romanian courts do not like and do not accept cases on merits. When we have a matter of provisional arrests, but Ukraine, Georgia, and Russia, you will see that it allows to consider matters with foreign element in corresponding local courts if there is property located in Ukraine. And so this is the question whether the particular ship is treated as the property in the country. And of course, it's subject that between the parties there is no jurisdiction agreement in the arbitration clause in their main agreement. So, providing a brief summary, I would say that although under the pandemic circumstances, we see that there is much more appetite between the parties to renegotiate, to give extensions, to give space for commercial settlements. From time to time, things happen, and when there is need, ships are maybe caught in any of the Black Sea countries, and many of them may be seen as friendly countries for arresting ships or releasing ships. There is only one country which is not on the map of our slides. This is Moldova. I would say that unlike in other 6 countries, Moldova has at the moment quite poor court practice as for arresting and correspondingly as for releasing the ships. There is only one port, Giurgiulești, situated on the Danube River, and so we are all looking to developments in this country to put it into our slides in next years. Probably that's all of my talk. I don't see any questions in the chat. Thank you very much for your attention, and let me come back as a moderator and let me pass the baton to my friend and my long-standing colleague Alberto Battini. Alberto, buongiorno Alberto. Alberto is an Italian lawyer, our associated office for many years. He's founding partner of BTG Legal, Battini Traverso Grasso e Associati. And Alberto, for 7 years also, he resides between London and Italy. He moved partly to London to assist the London insurance market with the Italian exposure. Alberto, the floor is yours.
Thank you very much. Let me quickly share the screen. Okay.
Slideshow, please.
Yes, which obviously is not here.
No. On the top, you can choose
function F5. Yeah, on the top.
You see on the top where is red.
Chat. Your screen sharing. Hang on.
Put the pointer. You see, you're now at the home. You need to move to the right to the slideshow, or on the bar, on the red bar.
Yeah.
On the top of the screen.
I can't see it, but anyway. I can't see, but anyway, it doesn't matter. Can you see the screen?
Okay.
Can you see
yes,
the slides?
We can see
yes,
the slides.
Perfect. Anyway,
so
it's no
you
problem.
can go on, no problem.
Okay, so I've tried to put together a few slides on the issue of decarbonization again, with a particular angle, which is basically the drafting of a few dedicated charter party clauses to basically try to resolve the tensions between owners and charterers that are expected in the next generation of charter contracts. The shipping world is of course going through what can be defined as an irreversible challenging regulatory framework, which comes out of the decarbonization process, of which Grant Hunter of BIMCO briefed us before. The cost and risk of complying with this new decarbonization measure will have to be allocated between owners and charterers very soon in the next generation charter contract. So it is important to consider some main areas for the purposes of drafting charter parties. Now, the first area is the IMO CO2 greenhouse gas emissions reduction measures. The second area is the area of data collection and drafting clauses that ensure a cooperation between owners and charters on CO2 data collection, which of course are crucial for managing the entire decarbonization process as far as the shipping industry is concerned. And the third one, on which Grant Hunter has already made some introduction, is the emission trading system, mainly focused on the EU at the moment, as Grant was saying, but with an eye, of course, to the rest of the world. So these are the main areas to consider. Now, coming to the first one, which is the reduction measures in CO2 and GHG, greenhouse gas emissions. Now, the IMO, as Grant mentioned, adopted this June this year, some amendments to the Annex 6 of the MARPOL in respect to energy efficiency existing ship index, EEXI, and CII, carbon intensity indicator regulations. So these amendments will enter into force on the 1st of November next year. And the certification for EEXI and CII will come into effect from 1st of January 2023. So owners will need to meet these regulations, and on the same side, charterers' intended use of the vessel will for sure cause frictions, cause tensions and differences in charter party negotiations, which will have to be composed. And of course, BIMCO is playing, as usual, a crucial role in drafting sensible clauses, balanced enough to be considered by owners and charters and their brokers when negotiating charter parties, both time charter parties, of course, and voyage charter parties. I'm referring to both. But of course, with time charters, this is a more sensitive area, of course. But voyage charter also will see some clauses in that respect as well. Has a word to say. Now, there are three different ways basically to reduce CO2 through operational efficiencies, and the three main area which we shall go through quickly are basically the slow steaming and the clauses, the charter party clauses associated with the slow steaming, the weather routing clauses, and the port rotation optimization. These are the three areas in the three different ways, which main ways to reduce CO2 through operational efficiencies. So slow steaming. So usually we know that slow steaming or consumption clauses in time charter party almost invariably represents a right of the charterers. Now, these may need to become also a right of the owners to meet the reductions in CO2 and GHG emissions. Of course, without violating the basic rules of English charter party, English contract law on utmost dispatch and deviation. But of course, this is the effort. This is of course from a contract drafting point of view to make the usual slow steaming or consumption clauses also built it in a way that they become also a right for owners to be invoked in a binding way for charterers. Weather routing, of course, owners must have the right to proceed by the most fuel efficient route or route in an American accent. The most fuel efficient route is of course a future standard to be taken into consideration in weather routing. Of course, up to now, this is not the situation. Up to now, we are looking at the commercial route or the customary route or the most direct route when weather allows it. So as a matter of English law standards, but this has necessity to become the most fuel efficient route. Now, to do this, to achieve this result, we would need bespoke language. We would need to have very clear language. in the contract, in the charter party, to make clear that proceedings on that basis is not a breach of the charter's orders, and as I said before, is not a breach of any utmost dispatch obligation or deviation. This is something, of course, that the owner don't want, is a risk that the owner don't want to run, because it would be very penalizing for his interest and, of course, for his insurance covers and all what is attached to that. And the third one is the port rotation optimization. Now, the bunker consumption and emissions of greenhouse gas may be reduced by the adoption of what BIMCO recently, of a BIMCO clause which was recently drafted and which they called GIT, just in time. Now, the just in time or GIT BIMCO clause, especially drafted for voyage charter parties, is if properly adopted, might be a solution and might be a good and balanced solution for port rotation optimization. This clause, which would see in the moment we have a slide on these, overrides the traditional obligation on ship owners to proceed with due or utmost dispatch or to avoid any type of deviation. The benefits of this of the adoption of this clause under the correct performance out of this clause include reductions in fuel consumptions, emissions, and waiting times. This is also due to the fact that the shortest route is not always the most fuel efficient route. There are possibly currents, wave ports, anchorage issues that may make the shortest route not necessarily the most fuel efficient one. So this is the BIMCO just-in-time arrival clause for voyage charter parties 2021, elaborated by and launched by BIMCO. It basically says that the owners and charters, first of all, shall use their best endeavors to obtain and to share information regarding the vessel's arrival time. So the first obligation is an obligation of best endeavors in order to share information, to collaborate on information. What does best endeavors means? Of course, best endeavors might be more than due care. In the Tojo Maru 1972 Court of Appeal, English Court of Appeal, which is a salvage case, quite a famous leading salvage case, best endeavors has been defined as a subjective measure of care that depends on the particular owner or charter. In that context of salvage, others commentators may have had different views, and Nick Gaskell was one of these. But anyway, so best endeavors is quite a high threshold of level of obligation to share information. The charterers shall be entitled to request to the owner in writing to adjust the vessel's speed in order to reach a particular destination within a certain time, and which may or may not coincide with the normal route or the normal time framework that the vessel or the normal planning that the vessel will have in mind. Such request shall always be subject to owner's consent, though. So this is very important. There are no imposition here. The owners will have to consent to these. Consent, of course, not to be unreasonably withheld, but still consent. The extra time that were calculated as the difference between estimated arrival time and actual time of arrival will have to be compensated by the charters to the owners at a fixed US dollars rate per day or pro rata. So again, in an effort of BIMCO to make the regulation as balanced as possible. And so the GIT arrival clause is certainly an important tool in this respect. As far as reduction of cargo intake is concerned, this is something that both the industry and experts in decarbonization are discouraging the owners to do. This is probably the owner's choice. The owners has the choice in to reduce cargo intake to consume less fuel, and in an effort, of course, to reduce the risk of a poorer CII rating. However, of course, these at the moment certainly would constitute a breach of any cargo capacity warranty included in the charter party, and the potential breach of other clauses, such as those relating to the following the charter's orders, allowing charterers to have the whole reach of the vessel's hold and cargo space benefit from the entire capacity of the vessel. These certainly at the moment are breaches, would be breaches of these warranties and these obligations, which you would find in charter, invariably in any charter party or at common law. But certainly these may be tweaked in order to in future, in order to try to avoid these harsh consequences for the owners by drafting appropriate and bespoke wording. But nevertheless, this is an option which is generally discouraged to be followed. Others have to be preferred, and we saw some of these before. In terms of biofuels, some consideration. There has been a lot of talking about the use of biofuels. Now, the considerations to be made are, first of all, we have to ask ourselves if the trial or the use of biofuels will start under an existing long-term time charter or under a new time charter party. Because the consequences, of course, would be different and would certainly be different. All clauses relating to bunkers will also need to be considered, including the usual bunker quality specification clauses, the bunker price, the bunker on delivery and bunkers on redelivery clauses, etc. So these, of course, will be clauses that will have to be carefully scrutinized. Considering also that there are no standard specification for biofuels, so the wording should include, for example, that the charters must provide biofuels of a quality and of a specification which are approved by the engine manufacturer in the absence of standard specifications. The performance warranties also will be affected by the use of biofuels. Speed might be reduced. The potential inclusion of a tank cleaning clause might be required, and also consideration of the maintenance clauses and dry dock clauses. So all these, when of course biofuels enter into the game and will do more and more in future. We're already talking about, of course, hydrogen ships. We're talking about biogas ships, and etc. So all these will impose a revision in terms of closing charter parties, also of particular time charter parties, of course, here on all these specific clauses regarding bunkers, and this is also relevant for decarbonization, of course. Now, the second area that I mentioned initially regards the CO2 data collection clauses. I've copy-pasted here basically some materials taken from the UK P&I Club website on the Sea Cargo Charter. Now, very briefly, what is the Sea Cargo Charter? Now, following the launch of the Poseidon Principles in 2019, a group of cargo owners, very large cargo owners, including Trafigura, Cargill, and others, and ship owners on the other side, including Norden, Stenabal, Guranov, they get together and elaborated an agreement for the reporting of emissions relating to chartering activities. So basically, the Sea Cargo Charter is an agreement binding on the parties upon, of course, them signing this and getting into it, that about reporting of emissions relating to their activity. The Sea Cargo Charter was launched on 7th of October 2020, and basically it aimed at providing a global transparent framework and the baseline for assessing and disclosing the climate alignment of chartering activities against which are now known to be the IMO's absolute target, which are quite harsh, as of course that includes the reduction of shipping emissions, GHG emissions by the shipping industry of by at least 50% of 2008 levels by 2050. So this is of course quite a high threshold and an absolute target to be met. And of course this initiative, since its launch, saw a number of signatories being steadily increasing between cargo owners, cargo interests on one side and ship owners on the other side. Now, the Sea Cargo Charter, in its intentions, applies to basically in the charterers, first of all type of charterers that simply has an interest in the cargo on board or simply charter out vessels, the vessels that they charter in from someone else, or who are disponent owners themselves, or that simply are in a charter party chain between head charter and a number of sub-charters. It applies also to bulk chartering activities on vessels, which are employed on a time or voyage charters, and this includes contract of affreightment, dry bulk carriers, chemical tankers, oil tankers, LPG tankers, or liquefied gas carriers, or vessels that in general are engaged in international trade, where inland waterway trade are always excluded anyway. So this is the area of application of the Sea Cargo Charter and the subjects involved. The Sea Cargo Charter elaborated also a clause called the Sea Cargo Charter Clause, which is so not a BIMCO clause this time, which is a recommended charter party clause for voyage data reporting. And basically the clause basically provides that the head owner or disponent owner, whoever along the chain, shall provide a duly completed fuel emission report in a specific format, which is attached as a data collection template within 7 days after the completion of the voyage. This provision anyway, by express will of the draft of this clause, shall not affect any rights or obligations under the relevant contract. So that of course will prevail. And in case of conflict with other contractual provisions, such other provisions will always prevail. But in the absence of a conflict, it provides, it set out an obligation of the parties, and in particular of the head owner or the disponent owner, to provide a duly completed fuel emission report. So an obligation to share information. The third area is the emission trading system. Now, on this subject, we already heard Grant Hunter of BIMCO explaining us and informing us on the big progress that BIMCO is doing on the ETS allowances clauses. Now, what I want to give you is a very brief outline of the legislation on the ETS, with particular focus on the European Union, where ETS is at the moment quite advanced. Now, the old system rotates around the concept of allowance. So what is an allowance? The European Union allowance, which is a concept not very different from what is or will be the allowance in other parts of the world, means basically a virtual tradable unit under the European Union emission trading scheme or system, which give the holder the right to emit 1 ton of CO2, of carbon dioxide, or the equivalent amount of 2 more powerful GHG greenhouse gases, such as N2O or PFCs. So basically, it's a license to pollute. Now, the license to pollute, because you are polluting, is limited. And you have only a certain allowances. They didn't want to call it credits. It didn't sound well in this context, but allowances, and you cannot really overcome that. The concept is not new. We already have similar concepts in place in fluorinated gas, basically the gas that you have in your fridge or the gas that you have in your air conditioner in your car. That's already a type of pollutant whose use and consumption and trade is expressed in tradable unit between the operators of that particular market, the F-gas market. This is a very similar concept on a wider scale. And on 14th of July 2021, basically the European Commission adopted the package of proposal, which included bringing shipping and the shipping world into the EU ETS system from 2023. The EU ETS system, as I said, covers also other areas, not necessarily the emissions from shipping, but European Union, European Commission decided to bring also shipping into the EU ETS, and of course, shipping is an area, is an industry which is officially recognized to be contributing very heavily to carbonization. So under the proposal, the shipping will be added in the system on a gradual basis, so it's in a staggered way, from 2023 onwards. When the ship owners will have to surrender enough European Union allowances to cover at least 20% of their emissions. And this threshold is expected to rise to 45% in 2024 and 70% in 2025. And then from 2026, ship owner will need to surrender EUA to cover 100% of their emissions under the scheme. So be, as we say, carbon neutral, totally carbon neutral. So this is the idea and the legislation at the moment. Now, as I said before, the old system rotates around the cap, which is set on a company's permitted emissions, and then there are spare emissions that may be traded. As far as shipping is concerned, it will likely apply to the ships over 5,000 of gross tonnage, and also in respect of emissions from ships that perform voyages with carrying passengers or cargo for commercial purposes, and therefore this includes ballast voyages as well. And it will include all emissions from intra-European Union voyages, and all emission occurring while a vessel is at berth in a European port, 50% of the emissions from a vessel's incoming voyage to an European Union port from a third country port, and 50% of emission from a vessel's outgoing voyage from an EU port to a third country, to its next third country outside EU. So in the first instance, the shipping company, how it's defined in the text of the legislation, it's the exact words are shipping company. They're not speaking about ship owner. The shipping company will be liable. Now, the term shipping company has been defined in the European Union legislation by the ship owner, by basically a definition which match with the ISM code definition. So the ship owner or any other organization or person, such as manager or bareboat charterer, that has the responsibility or has assumed the responsibility for the operation of the ship from the ship owner. So it's basically matching with the ISM code definition. Now, as the liability would be on the owner in the first instance, of course, as we heard from Grant Hunter before, the effort is to how to shift this liability down to charters, how to pass this liability down to charters with specific clauses. And of course, Grant briefed us about the ETS allowances clause for the time charter party, and informed and updated us on the progress of BIMCO in drafting this clause, which would be, as I understand, ready by, if I'm not wrong, January next year. Now, the inclusion, of course, as I said, of a suitable clause in the charter party would be necessary, because to pass this liability down to charters, because otherwise it would be an owner's liability. Very important would be to include an adjustment mechanism to ensure that the EUA price is at the relevant time is applied. And so there are basically a correct adjustment in the, since this is a variable price and of course fluctuates, we don't have any distortion of the system arising out of that. So this is basically it. Thank you very much for your patience. And
Alberto,
back to Arthur.
Thank you very much. Thank you very much. As you're based in London, I would say that last years, 2-3 years, that were very challenging. Brexit, then pandemic, now decarbonization. So, and you are just in the center of all this. I'm sure that London people, London shipping people, will adapt to all decarbonization matters first of all. But what do you think? How, what, for example, P&I market says, how much time is necessary to, you know, to get understanding over all these decarbonization clauses, matters, and consequences?
Well, I think that the insurance industry and the P&I in particular are at a very advanced stage of understanding all this and in reacting to this new legislation and new regulation at MARPOL level, European Union level, and at a regional levels. I have more doubts, or some doubts at least, on some shipping industry. I don't think some shipping industry is ready and will be ready very soon, unfortunately. I'm not referring to any particular region, but of course, as we all know, there are a great share of shipping industry which have obsolete tonnage, which will struggle more than others to convert or modify the engine and mechanical systems, propulsion systems to meet these new regulations, will not be sufficiently financed at the moment to change tonnage with new or more recent tonnage. So we'll be stuck. Of course, I'm not referring to the big ship owning interest, but to all the others. So, and in particular regions of the world as well. So we'll see. It's going to be a big challenge. We'll see probably some ship owners disappearing, and we'll see probably some others flourishing, as in every big change or game-changing situations. Thank you.
Yeah, thank you very much. I'm sharing, really sharing your opinion. Geographically, probably I have also a comment that probably geographically northern countries will be the first ones because they're, let's say, more disciplined probably in that, more disciplined than in that southern countries. But for sure, it's a big change, so big game. So we will see big developments. Yeah. Thank you very much, Alberto. And now we have Krzysztof Kowalczyk online, our associated office and partner of BSJP from Poland. Krzysztof is a competition and dispute resolution lawyer from Poland. The floor is yours. What's going on in Poland from your side?
All right. Good afternoon, everybody. I hope you can see me and I hope you can hear me well.
We can.
Kowalczyk, and I'm an attorney, partner, and head of dispute resolution team in BSJP law firm in Warsaw, Poland. First of all, I'd like to thank all of you for being together with us today. I'd like also to thank Interlegal and Artnur personally for inviting me to participate in today's event. It is a big pleasure for me to be able to speak in front of you today. But as the time is of an essence, let's quickly proceed to the merits. What I'd like to speak on today is the influence on current COVID-19 pandemic on the commercial arbitration. The topic has already been touched by Danielle earlier this morning, but what I'd like to say is, how does this work in practice? Based on an example. So I'd like to focus on the law in action, not on the law in books in terms of US Supreme Court Justice Oliver Wendell Holmes. And my motto for today's short speech is by William Shakespeare, who in his immortal Hamlet at the end of 16th century reminded us that there are more things in heaven and earth than are dreamt of in your philosophy. Especially in the era of COVID-19 pandemic, we have been seeing so many changes in the reality that surrounds us. There are lockdowns, other restrictions, our friends and family members get sick, go to hospitals. Some of the people we know ultimately lose their fight with the virus. The bad side of the pandemic is well known to us, sometimes way too well. Is there, however, a good one? From the very beginning of human civilization, calamities were, to some extent, one of the drivers of mankind progress. As an example, let's say that the recent World War II brought to the world antibiotics, jet engines, nuclear energy, and many, many other inventions. There were also plagues. Black Death in the 14th century has totally changed the structure of Western European society, increasing the role of peasants. It was so because the amount of land as a production factor remained unchanged, while the number of peasants who were able to harvest that decreased significantly. The other driver of mankind progress is ordinary laziness, but I'm not going to elaborate on that today. The question is what the current COVID-19 pandemic brought to the legal world. How did the pandemic change our small legal society? The initial observation I'd like to make at the very beginning is that lawyers are generally conservative and they adapt rather slowly to all the changes, novelties, and so on. Personally, I see two main changes in widely spoken performing of the legal profession in and after the COVID-19 era. The first of them is the introduction of the remote work. The second one is the widespread of the virtual hearings. Much has already been said of the remote work, which I believe will remain with us beyond the pandemic. So I'd like to focus on the virtual hearings today. And one of the key notions used by lawyers, especially litigators, is the notion of hearing. The hearing is the key moment of the proceedings when both parties produce evidence, summarize their positions and the arguments. From the very beginning of civilization, the hearings were held in public with the lawyers using their verbal skills to convince a judge that their client is right, while the opponent's argumentation shall be dismissed. The avant-garde of a dispute resolution is indeed the arbitration. The arbitration serves as a kind of a testing range on which some new ideas are being tested. If they work well in the arbitration field, some of them are consequently transplanted to the common courts. One of the advantages of the arbitration is its flexibility. I understand the flexibility of the arbitration as the ability of the parties, together with the tribunal, to set the rules for the proceedings. Obviously, if no agreement is made in that respect, the basic rule of the arbitration institution in question, referred to in the arbitration clause apply. The virtual hearings were to some extent used in the international arbitration before COVID-19 era. The doctrine listed time and cost savings as two main advantages of the virtual hearings. The online hearings were, however, not so common before 2020. The situation has changed dramatically in the spring of 2020. Be it of the parties or tribunals initiative, many pending arbitrations transferred to the virtual world, and the virtual hearings started to be commonly used. That concerned not only so-called new arbitrations, but also the proceedings commenced in the traditional way before the pandemic. As an example, I'd like to refer to the arbitration to which I have a pleasure to be a part of as one of the attorneys to the plaintiff. The arbitration I'd like to speak about has been commenced under the FCIArb rules in Warsaw, Poland in late 2018. The claimant is a Spanish construction company which claimed some 150 million euros in damages and remuneration under the construction contract regarding a polder in southern Poland. The defendant, a public entity, moved for dismissal of the claims. Moreover, the defendant filed a counterclaim amounting to some 100 million euros. Thus, the total value in dispute leveled up to about 250 million euros, making that case one of the largest arbitration proceedings currently pending in Poland. During 2019, the parties exchanged the pleadings. At the beginning of 2020, while the pandemic situation in Poland was not so harsh as it is today, the tribunal met with the parties in order to have the organizational hearing. The claimant hired 2 law firms, while the defendant hired 1 law firm and also used the attorneys to the state treasury. Therefore, to my recollection, there were more than 20 people in a courtroom, 3 arbitrators, a secretary to the tribunal, and approximately 10 attorneys per party. Shortly after we decided on the details of the prospective hearings, the pandemic situation worsened significantly, and there was a lockdown instituted in Poland. Thus, the tribunal has contacted the parties, asking for their consent for switching to the online format. I might say for the claimant part only, but we had serious doubts how would that work. We had so many witnesses to hear, some of them with participation of interpreters. Would that work? How about the quality of the connections? But after a couple of days, we were really convinced that either we risk going online or we lose several months or even years. Finally, at the day set by the tribunal for providing answers from the parties, the tribunal has received 2 goes for the online hearings. Now, we had to teach ourselves how to use the software to be used in the case. It was Zoom Pro. We set up several test connections, firstly between the attorneys. Finally, there were 1 or 2 test connections between that tribunal and the parties together with their attorneys. Due to the sanitary requirements, particular attorneys had to sit in their rooms. Then we had some more than 20 icons displayed on the screen. The test, however, had gone well, so finally we were able to move to the real hearing. There were also almost 50 written witness statements filed. Some 30 witnesses were chosen by the parties to be cross-examined at the hearing. Moreover, there were approximately 10 expert witness opinions on various topics produced by the parties. All expert witnesses were asked to testify during the hearing. The language of proceedings was Polish, but many witnesses or expert witnesses were to testify in English. Therefore, interpreters has proven to be necessary. Finally, it was agreed that there would be 3 weekly series of hearings with some time gaps between them. The hearings usually started at 9:30 a.m. and lasted until 6 p.m. with a 45-minute break. It was very exhaustive, but manageable. The tribunal sat in a courtroom while the attorneys were separated, as I already mentioned. Zoom Pro, together with a secretary to the tribunal, or rather the secretary to the tribunal with a little help of Zoom Pro, did it perfect. We had no problems with connection at all. Also, the audio and video quality was, I'd say, at least sufficient. During breaks, attorneys to particular parties were directed to breakout rooms where they could talk freely without participation of either tribunal or the opposite party. Prior return to the plenary sessions, the relevant information was posted in the break room, so everybody did perfectly know what will be going on in a moment. As per witnesses, some of them were in Poland, some in the UK, some in Spain, as far as I can remember. One of them was located in as far as in Mexico. Another issue we had here was how to ensure that nobody is supporting the witnesses during their cross-examinations. In the routine way, the parties would have designated a person to supervise each witness. This was, however, not possible for all witnesses due to the sanitary requirements. Nobody could enter the room in which a witness was present. So we had to solve that issue. The solutions suggested by the tribunal and finally accepted by the parties was that before the beginning of a cross-examination of a certain witness, that witness was just to move the computer or move the camera around, just to show the room in which he was to testify, in order to ensure that nobody was with the witness in the room, so nobody was supporting that witness. Of course, during the hearing, during the cross-examination, each of the parties had the right to ask a witness to repeat that procedure to be more than 100% sure that nobody is disturbing the witness, nobody is supporting the witness. This was used only once or twice, as we had a trust, as a trust is one of the key factors in the arbitration. After each of such weekly sessions, we had received transcripts from the hearings. And I might say there were usually more than 100 pages per day, so we had a good lecture for long nights. Finally, we came to the end of that phase of the proceedings. Currently, the closing pleadings has already been interchanged. We are awaiting a decision on formal closing of the proceedings by the arbitrators. We believe this is going to happen either this or the next week, and the award itself is expected by some late spring 2022. Some comments from my side. That story wouldn't never happen without the pandemic. In the ordinary, routine and conservative legal world, we would rather tend to gather together in the courtroom in Warsaw, request the witnesses and expert witness to come to Poland and testify from there. So much money was saved on travel costs just due to moving online. And it happened, in my opinion, without losing the quality of the proceedings. So what I would recommend, of course, is let us lawyers remain a bit conservative, but we have to be more and more open to the opportunities facing us. Let's expect the unexpected and let's adapt to that. Everything for sake of good of our esteemed clients. At the occasion, I'd like just to mention that effective mid-2021, all common courts in civil matters in Poland were, by respective changes in legislation, just obliged to switch to online hearings. Of course, as with the novelties in a conservative legal environment, after the law was published, there was a horrible resistance by some of judges. But finally, even the most reluctant ones slowly realize that the online hearings are a good solution for the difficult times we are living in. And I believe that those online hearings will stay with us longer than COVID-19. However, it would be good to meet in person from time to time, and I wish that we meet in person at the occasion of the next edition of this conference. Thank you very much. Should you have any questions, just please do not hesitate to contact me. You may contact me over my email, which is krzysztof.kowalczyk, name and surname, @bsjp.pl. Have a great day and stay tuned for the next speaker.
Dziękuję bardzo.
Bardzo proszę.
Krzysztof, yes, right. You have very good slogan that new techniques, online hearings have come to our business life very easily. So a few years ago, we could not expect this to happen so quickly.
This is why I chose Shakespeare here to show that something unexpected is being rapidly getting into our world.
Yep, correct. And for example, in our countries, sometimes judges or parties or arbitrators, they say that, of course, there is a lack of, let's say, emotions in hearings when you are online rather than in one room. But on the other hand, let's just imagine if online solutions were not provided, how during these 2 years all procedures could be handled. And there are more advantages because it saves really time, it saves money to parties for traveling, for staying at hotels, because sometimes we know when in arbitration it may take a week, yes, for a witness or for parties to be at tribunals. So we have to be adaptive. We have to be flexible, more flexible, but because I like what you said, that it all benefits to our clients, and it all benefits to development of our profession. Right, you are. Thank you very much.
If I might say one thing more.
Sure.
Artur, when I'm asked about progress in the legal world, let's say, broadly said legal world, I always ask one question. Do you remember how this profession was dealing with technical issues, let's say 20 to 25 years ago? Who can remember faxes, telexes? Who can remember problems with organizing phone calls, with participation of phone calls abroad? Today we forgot that issues. We are facing straightforward to new techniques, and the online virtual hearings are one of them, which I believe will stay with us much longer than COVID. And yes, they will develop as even no later than yesterday or 2 days ago. There was some information from Bill Gates, who was anticipating that majority of business meetings will go to new 3D techniques in few years. So the virtual hearings we are facing right now are not the last word of the technology, and we may expect a huge development in technology in this respect. So we could feel one day or another, we could feel sitting in our rooms, in our offices, like being in the real courtrooms. Well, we will see.
Yeah. We will see. The only way is that next year I would like to have every one of you around me in presence.
Of
Let
course,
it be
absolutely.
let it be in 2 years, you know, let it be not next year, okay? Thank you very much.
I believe we will be able to do that next year, but we will.
Okay, thank you.
Thank you.
Krzysztof, thank you. The next speaker is from Spain. This is Diego de San Simon from San Simon in Duc. Diego provides advice to ship owners, charters, P&I clubs, forwarding agents, import and exporters, insurance companies, brokers, and shipyards. He's got wide experience in business law. Diego, come on.
Hello, Arthur. Are you able to see my
I
presentation?
can hear you, if possible, on the orange top bar. No, yes, to the right. You oh, correct. Bravo.
Correct.
Okay.
Okay, perfect. Well, first of all, Arthur, thank you very much to you and to all the Interlegal team for inviting me to be part of this online event. It's always a pleasure. As you already said, hopefully next year we will be able to share and to meet offline in Odessa. So let's cross fingers and wait for the end of this horrible pandemic. Pandemic, which brings me to the topic on which I will focus today. So as you can see in the screen, the pandemic outbreak, a state of alarm declarations, and consequential lockdowns have affected in several ways to the shipping international industry. One of its consequences has been a substantial increase of abandonment of the cargoes in Spanish ports. And I guess that this has been the same in other ports around the globe. When this happens and the consignee does not appear to collect the goods carried, one or several situations may occur. First of all, it may occur that the cargo is abandoned without further consequences, and which I call this as a mere or simple cargo abandonment. Secondly, it may also occur that besides the abandonment of the cargo, the freight and other related expenses may be yet due to the carrier. Articles 512 to 515 of the Spanish Shipping Act contain the provisions on the deposit and sale of cargo and luggage in the shipping carriers. Said articles establish that the rules on deposit and sale of goods and luggage shall apply when the applicable law to the contract of carriage entitles the carrier to request said deposit and sale in case of any of the cases or scenarios that you can see here in the screen. The first scenario is when the consignee does not pay the freight, the passage, or expenses related with the carriers. Second one, when the consignee does not appear to withdraw the goods carried. And third but not the least, when the carriage cannot be concluded due to a further circumstance arising during the trip that makes a continuation impossible, illegal, or prohibited. So, as we all know, when the consignee does not appear to collect the cargo, one or several of these scenarios may occur. And what happened when in the first scenario, when the consignee does not appear to collect the goods, and there is also a sea freight outstanding or other related carriage expenses also outstanding. In this case, when the law applicable to the contract of carriage is the Spanish law, the carrier shall only resort to the deposit and sale proceedings of the goods when the consignee is bound to pay the freight, either because it has been agreed and stated in the bill of lading, or because the consignee is at the same time the charter. In this regard, as you can see here in the screen, Article 235 provides that the charterer shall be bound to pay the freight under the conditions agreed. Notwithstanding, it may be agreed that the freight be payable by the consignee, this being recorded on the bill of lading. In this case, the consignee shall be bound to pay the freight if he accepts or withdraws the goods at destination. Should the consignee refuse or not withdraw the cargo, it shall pay the freight the party that contracted the carriers. So in this way, Article 235 provides that the charterer is obliged to pay the freight in the agreed conditions. However, it may be agreed that the freight is payable at destination by the consignee, being recorded in the bill of lading. So in the light of this rule, it is clear that the freight payment on delivery by consignee agreement does not mean that said consignee is liable to pay the freight in any case, but only when he accepts and pretends to withdraw the cargo. Therefore, a default payment by the consignee is not required to proceed with the deposit and sale of the cargo, but just that he has not paid said freight. And very important, with the limitation that the carrier may not exercise that right against a consignee other than the charter, except if the bill of lading mentions that the freight is payable at destination. Therefore, in the event of abandonment of cargo with the consequent freight outstanding, it shall be the charterer the liable party to pay said freight. Lastly, a no payment claim may be exercised a claim a consignee other than the charterer that does not withdraw the cargo. And the lien on the cargo, this is the right of retention, deposit and sale of the goods for freight outstanding, may only be exercised in case said freight payment corresponds to the consignee, either, as we have seen, because it is expressly agreed in the bill of lading, either because the consignee is also the charterer. All these rules are without prejudice, of course, the right of the carrier to resort to the mere deposit of the goods, abandon, which is the second scenario addressed in Article 512. But before this, just let me point it out that all these rules shall also apply to any delays or other expenses outstanding. Okay, the second scenario addressed in Article 512 consists on the mere deposit of the goods, abandon. This is when the consignee does not appear to collect the cargo, but there is no outstanding payment on freight and other related expenses. In such cases, when the law applicable to the contract of carriage is the Spanish law, Article 228 shall be observed. Said article reads that the carrier shall deliver the goods carried to the consignee authorized to receive the goods, without delay and pursuant to the terms agreed. However, if the consignee does not appear or refuses delivery, the carrier may store the goods until their delivery at the expenses of the consignee or resort to the deposit. In the light of this article, the carrier may be entitled to either resort to the deposit of the cargo, either to store said goods. In this respect, let me say that if the carrier seeks to avoid any eventual liability arising from the cargo's custody, we should choose always the deposit of the cargo rather than its storage. And putting the focus on the deposit, as already mentioned, Article 228 entitles the carrier to store the cargo or resort to its deposit if 1. The consignee does not appear to collect the cargo, or 2. He refuses delivery. Surprisingly, the refusal delivery is not expressly mentioned in Article 512 of the Spanish Shipping Act, which only refers to the event of the consignee not appearing to withdraw the cargo. In this respect, different authors have, in my view, pointed out correctly that it would be hard to believe that this second case should not fall within the scope of Article 512 and following. Therefore, in my view, and in view of almost all the doctrine, provisions contained in Article 512 and following shall also apply in the event the consignee refuses delivery. And the third scenario, which consists on the early termination of the contract of carriers, In this respect, Article 512 also reads that the rules on deposit and sale of the cargo shall apply when the applicable law to the contract carriage entitles the carrier to request said deposit and sale when the carriage cannot be concluded due to a fortuitous circumstance arising during the trip that makes its continuation impossible, illegal, or prohibited. In this regard, and once again, when the law applicable to the contract of carriage is the Spanish law, Article 274 shall be observed. This article reads that if circumstances were to arise during the trip that make it impossible or prohibit its continuation, the carrier may call into the most convenient port for the common interest and unload the cargo at said port, demanding the charter to take care of the cargo at that place. Therefore, Article 512, in accordance with this Article 274, confirms the right of the carrier to resort to the deposit of the cargo, not only at the agreed port of discharge, but also at any port that the carrier should have been forced to call and discharge the cargo as a result of the early termination of the contract due to further circumstances arising during the trip. This Article 274 also states that the carrier shall be entitled to the freight in proportion to the distance covered. So it is to be understood that in the event the consignee does not pay the partial freight, the carrier may also resort to deposit proceedings and sale of cargo, with the same limitation with regard to a non-charter consignment previously mentioned. However, as we all know, generally speaking, charter parties and bill of ladings in most cases are not governed by Spanish law, but by foreign laws, which means that pursuant to our Article 512 and following, the carrier who seeks the deposit of the cargo or the deposit and sale of the cargo shall prove to the notary public, which is the authority, the competent authority to conduct the deposit and sale proceedings, that the foreign law applicable to the contract of carriage entitles the carrier to request said deposit and or deposit and sale, unless the notary public knows the foreign law, which logically is actually rather unlikely. With regard to the proof of the content and validity of the applicable foreign law, it is our view that it should be not necessary any irrefutable evidence that the foreign applicable law to the contract of carriage entitles the carrier to request the deposit and sale of the goods, but prima facie evidence of said contents and validity, or in a case-by-case basis. In any event, the notary public will be entitled to request information on the foreign law in accordance with the International Legal Cooperation Act. And just to finish, let me just point it out that the proceeding is not a complicated proceeding. This proceeding is especially focused on the deposit and sale of the cargo for lack of payment. And one special case is that in case we are in a mere deposit, this is when there is no outstanding freights, the sale of cargo shall also be appropriate when there is a risk of damage to the goods, or when due to their conditions or other circumstances, the conservation or custody expenses are disproportionate. And that's all. Thank you very much. I think
Diego, thank you very much for your input. Tell us, please, what was the landscape? I mean, what was the volume of abandoned cargo? Here at our end in the Black Sea, we have not felt, any volumes of abandoned cargoes. Partly, I explained this, that's generally the volume of cargo traffic here was quite stable, quite low, let's say, probably on the lowest possible level. That's that's why we have not faced such a matter as a critical point. But as far as I noticed in Europe, especially in Spain, that was the case. That was vice versa.
Yeah, well, at least in our experience, we saw that during the first part of the pandemic outbreak, in particular during the state of alarm declarations, as we saw, I think people got a little bit frightened. So we saw a considerable increase of the abandon of the cargo in Spanish ports. Then I think more or less everyone started to feel a little bit more comfortable, and happily this was not the rest of the months of the pandemic was better in this respect.
Thank you, Diego. Thank you for your input. Thank you
Thanks
for
to
your
you.
support. Yes, hopefully again also we will be pleased to see each other next year.
Yes, of course.
Online. Okay. With my pleasure, I'm passing the microphone to Larry Carvalho from Mare, Brazil. This is first appearance of Larry at our events. We have known each other for many years. This is our correspondent in Brazil. We had a few cases together during last 10 years. So Larry is based in Fortaleza. He's able to operate in all Brazilian port cities through his extensive network of legal correspondence. And Larry, the floor is yours. Please share the screen, appear on our screen.
Hi, Arthur. Glad to be here speaking to you guys today, to you all. And many thanks for the invitation to be here and to be present and to speak on your event, on the Interlegal event for the first time. I'm just sad because we couldn't do this in person. We have to do it online.
Larry, one moment. Can you press the button mute, because we have two voices from you. Please unmute.
Okay, just a moment.
No. Turn on back. You have to, when you use microphones, you have to make unmute on the laptop or on the computer that you use. Okay.
Okay, so can you hear me now?
Yes,
okay?
yes. Now it's very good. Thank you.
Perfect. Well, I think it was recording my voice through the headphone and through the computer also. So,
right.
So as I was saying, I'm very glad for the invitation to be here and to speak for the first time in the Interlegal event. I'm just sad because we cannot do the event in person, but hope next year we can. And Artnur, many thanks for the invitation, and many thanks for all the Interlegal colleagues also for the invitation to be here today speaking to you all. The theme of my speech today will be the situation here in Brazil due to COVID and all the sanitary restrictions, and why the sanitary restriction has impacted the charter agreements here in Brazil also. So things are moving really drastically here in Brazil, mostly due to the Omicron strain. So the last 2 weeks, we had a lot of new developments here in Brazil concerning the sanitary rules and vessel quarantine also. So I'm going to try to explain. The situation is not so straightforward because we had a lot of intervention, mostly from the Brazilian Supreme Court. So the newest resolution that we have is, let me try to share my screen here just a moment, Artnur.
Larry, sorry, there is no sound. We can see the screen, but there is no sound.
You can hear me?
Yes, we can hear you.
Okay, so let's go again. So the last week we had two new resolutions. The resolution number 648 dealing with the health and crew change proceedings, and we had the ordinance number 661 dealing with the requirements for entry of travelers by air and by road here in Brazil. And things got really messy because you see on the ordinance 661, the Brazilian government established a vaccine mandate here in Brazil. And they also provided alternative quarantine for travelers coming from air or for road here in Brazil. So if you didn't have full vaccination, you could do like a 5 days quarantine in a hotel or in your house when arriving in Brazil. And after 5 days, you would have to do a PCR test or a rapid test also. If you were tested negative, you could go out from quarantine. And if you didn't want to do the quarantine, you could stay in quarantine for, if you didn't want to do the testings, you had to stay in quarantine for 14 days. And this new regulation was on December 8th. And what we had was in December 10, the Ministry of Health here in Brazil suffered a ransomware attack. So we suffered some attacks from hackers here in Brazil, and they couldn't implement the enforcement of the vaccine mandate at the airports. So what they did was they postponed the enforcement of the vaccine mandate to December 18. And this was done by the Ordinance 662 here in Brazil. So currently, we are waiting until the 18th for the vaccine mandate to be enforced here in Brazil. But the thing is, on December 11, so this Saturday, the Justice Barroso of the Brazilian Supreme Court issued a decision here stating that the alternative quarantine of 5 or 14 days for all the travelers coming by air or by road to Brazil was forbidden. So the Supreme Court forbidden such kind of quarantine in order that every traveler coming to Brazil must present the full vaccination proof. And what happened is we are currently in a gap, because you see the regulation was supposed only to be enforced on the 18th, but in some airports, people are already being required by the Brazilian authority to present the full vaccination. So there has been a lot of problems the last 2 days, and I think we will suffer these problems until the 18th, because some authorities are already requesting the full proof of vaccination. However, by Brazilian regulation, this should be only required on December 18 onwards, you see. But due to the Brazilian Supreme Court decision, some authorities are, well, they are reading and probably reading wrong, and they are thinking that the mandatory full vaccination is already in force, you see. So we are facing a little bit of legal uncertainty here in Brazil, and a lot has happened these 2 past weeks because of this. But either way, whatever you have to present the full vaccination or not when you're arriving in Brazil, the fact is, after December 18, it will be mandatory to present it. Either way, also, it's required if you're a seafarer and you want to embark here in Brazil in a vessel, you will need to show proof of vaccination to embarking in Brazilian waters. And more often also, a lot of ports here in north and northeast of Brazil, and already some ports in southeast of Brazil also, are starting to demand proof of complete vaccination to access their area. So for admission to the port and terminals, usually you will be requested to present proof of full vaccination. So even if you don't have to present it when you're entering Brazil, you will probably be required to present full vaccination to embark the vessel or to enter the port also, or the terminal. So there are mainly three things that a seafarer and ship owners need to present to Brazilian health authority when they want to do crew change proceedings here in Brazil. And the first one is, as I just said, proof of full vaccination. And the other one would be proof of negative COVID test. And the crew members can do a rapid antigen test performed 24 hours prior to the embark or disembark, or they can do a PCR test, and this could be until 72 hours before the embarkation or disembarkation. And also, the master and the crew members have to carry out a symptom screening for COVID for all of those that are going on board the vessel. See, there's also a restriction, mostly due to the Omicron restraint. And in this is that all travelers coming from the red list countries, and the red list countries are South Africa, Botswana, Kingdom of Lesotho, Kingdom of Eswatini, Namibia, and Zimbabwe, need to stay for 14 days quarantine before going on board any vessel. And of course, as soon as they arrive Brazil, they have to do a quarantine here in Brazil. And there are some ports and some local health authorities that are even requesting a full 14 days quarantine for any vessel that's coming from such ports also. And the thing is, here in Brazil, we have the federal rules for quarantine and for sanitary, but for some reason, and this is quite strange, but this is how things are here in Brazil. Depending on the port and depending on the local health authority, he may have different interpretation of the rules. So by the book today, when a vessel is arriving from one of the red listed countries, by the book, the vessel won't have to do a quarantine. Only mostly the crew members, if they're arriving by air or in the Brazilian airport. But there are a lot of ports and local authorities requesting a 14-day quarantine also for vessels coming from those regions, see? And here in Brazil, for medical assistance of crew members, and this is a question that I receive a lot from ship owners and P&I clubs also here in Brazil, is whatever seafarers can receive medical treatment here in Brazil. And yes, they can. They can receive both treatment for COVID and for no COVID issue, and also for dental care here in Brazil also. However, if there's no emergency for the medical treatment, usually the health authority will need to give their clearance first, and they will first analyze if the case can be dealt on board, and if no, they will probably allow the crew member to disembark and to do the medical treatment here in Brazil. And on this situation, they will require proof of negative COVID. However, in cases of emergency, the disembarkation of the crew members can be done without COVID testings and without any prior authorization of the health authority. This is because of the emergent situation. So to don't suffer any delays or waiting the authorization from the health authority, The rule authorized the shipping agent or the ship owner to disembark the crew member, the seafarer, that's needing emergency medical treatment. But the thing is, the ship owner and the shipping agent will need to communicate until 4 hours after the disembarkation to the local health authority here in the port also. And the ship agent will need to sign a document assuming full liability for all medical expenses and transport for the seafarer that's being disembarked here in Brazil also. And the ship owner will have to sign also such document, and all the liabilities for expenses and for everything need to be borne by both ship owner and shipping agent here in Brazil also. And mostly dealing with COVID cases, usually the seafarer can be brought by to be attended on a public hospital here in Brazil. So probably there won't be any medical bill because he will probably be attended on a public hospital, because mostly the public hospitals are the major hospitals that are attending COVID situations and emergency also here in Brazil. And there are a lot of vessels arrival requirements and mandatory informations that the captain need to present prior the vessel arriving in Brazil also, and during the stay of the vessel here in Brazilian waters. So the requirements for free pratique are usually standard. It will be only granted if the captain and shipping agent forward to the local health authority the medical logbook containing the records of health occurrences in the last 30 days. And in the absence of the medical logbook, the captain and ship agent need to submit the local health authority when was the last medical occurrence or last symptom or last occurrence aboard for medical situation. And also the captain must sign a Maritime declaration of health and declare that the vessel operates under the rules for managing ships with one or more cases of COVID aboard also. So usually it's the same paperwork that the vessel would have to file pre-COVID. And of course, there are a little bit specifications because now the captain must declare that they are attending and they are doing everything by the books, and they are tracking and they're monitoring if they have COVID aboard or not. And you see, there are some informations also that the captain need to present to the local health authority. And the vessel must initiate a notification to the health authority here in Brazil of any health events or any medical occurrences at the minimum of 24 hours in advance and at maximum of 36 hours before the arrival of the vessel to the first Brazilian port also, using the fastest means available to send this information, this notification. Usually this is done by email directly to the local health authority here in Brazil with the assistance of their shipping agent nominated to the port already. And the vessel also needs to have a solid waste management plan here in Brazil and record the execution of related procedures. And all the solid waste generated when there are suspect or confirmed cases of COVID aboard must be treated as infectious and incinerated on board or collected by a specialized company here in Brazil that needs to have a special permit called business operation permit by the health authority and health minister here in Brazil, because they have to do a proper treatment and final destination of the waste here in Brazil. And regarding the pilot arrangements, earlier on the first COVID outbreak, we had a lot of problems with pilot arrangements, mostly on the north region of Brazil. And this was mostly because we had a hard time finding flights, because the north region of Brazil, their grid is not so good, and you don't have a lot of flights in north region of Brazil. So due to COVID, their grid went belly up here in Brazil, and usually ship owners couldn't find flights to take the pilots to some ports in the north, like Fazendinha, Trombetas, Manaus, and such ports suffered a lot. So usually ship owners would have to charter flights to take pilots aboard the vessel to perform the all necessary procedures to berth and unberth the vessel. So we ship owners face a lot of costs while sending vessels to north region of Brazil last year with flight costs. See some situations, ship owners had to face bills like 400,000 reais and 500,000 reais just for chartering vessels here in Brazil to take pilots to the north region. So the situation was real bad, you see. And also requirements in people in all today and since last week, a lot of professions that couldn't go aboard, like ship agents, ship protectors, and port operators, they mostly couldn't go aboard a vessel. But now, since last week, they can go aboard the vessel. But also, every time they go aboard, they need to pass a screening to see if they have any symptom for COVID. And they will have to show also COVID test before going on board the vessel also. And the biggest change here in Brazil last week with the new regulation was regarding the quarantine proceeding of vessels. Until last week, the only procedures that the ship owner could do when seafarer crew members were diagnosed with COVID was the vessel quarantine. And this led to a lot of problems here in Brazil. And not only in Brazil, but around the globe, because international trade suffered a lot with this. You can see this worldwide with a lot of vessels delaying the voyage due to quarantine proceedings. And here in Northeast Brazil, mostly we suffered a lot with this also, because here in Northeast of Brazil, we do a lot of export of fruits to Europe and to also to the Asia market. And the thing is, we do a lot of mango also to North America. And the thing is, we had to face a lot of problems here, and usually court injunctions were granted because on some situations, and mostly with cargoes that were perishable, like a vessel was coming here, a full container vessel was coming to the northeast of Brazil, and usually they will carry a lot of containers with fruits. And in some situations, these vessels were put on quarantine by the local health authority. And the thing is, on some situations, if the vessel had to wait until the end of the quarantine, and it was a 14-day quarantine, a mandatory quarantine, usually the vessel would suffer a lot of losses because of the perishable goods. And usually, on the situation that our law firm attended, usually you see vessels that could be liable for 14 or 10 or sometimes $20 million only due to mango and lime and melon cargo here from northeast of Brazil. And in a lot of these situations, we had to file court injunctions and request to the judiciary branch for court authorization to release the vessel from the mandatory quarantine and to allow the vessel to operate and to carry all the containers and to be allowed to sail to their final or next destination. And in almost all the cases, we were able to receive the injunction and to have the injunction granted here in Brazil. But in mind of this, a lot of ship owners and ship owners association spent a lot of months speaking with all the health authorities here in Brazil, trying to find different options. And finally, last week, we have the final word from the health authorities. So now in Brazil, we have three main options when a case is diagnosed, or when a crew member is diagnosed with COVID aboard the vessel. So the first option that the ship owner can choose from is to do a crew change. So when a vessel has one crew member or more crew members diagnosed with COVID, the ship owner can opt to disembark all unvaccinated crew members for a 14 days quarantine on shore instead of in the vessel. And after disembarking all the unvaccinated crew members, it's mandatory to do disinfectation of all the touch surface and all the vessel. And after this disinfectation and cleaning on board is done, the ship owner can bring new crew members on board and resume the operation or navigation also. The second option that the ship owner can decide upon is to have all essential unvaccinated crew members to stay on board and to work, to stay in quarantine in the vessel, but they can still work on board the vessel if they are asymptomatic, of course. And it's necessary to do a rigorous physical distancing on this case, and mask would be mandatory in all environment except on the cabins. And also this disinfectation must be done every 24 hours in the vessel. And if there are unvaccinated crew members on board, the vessel operation can be only resumed if the ship remains close to shore with approximately 1 hour from 1 hour to shore. So if there is any problems with unvaccinated crew members, they can be happily evacuated. See, and also the port operation can resume also if you opt for the second option. And the third option will be the temporary stop of all operations. So it will be the what we had before, is the vessel quarantine. So you have the 14 days on board the vessel quarantine for all non-essential and unvaccinated crew members. All the essential crew members that are vaccinated, they can still work, but they have to do physical distancing. And however, the ship operation must remain suspended. So the ship must be near the port. And if the ship is already doing port operation, doing loading or unloading operation, he needs to stop the operation. He can remain docked or berth, but the ship would need to stop the operation for 14 days, you see. So now there are three options that the ship owners can choose from. And in generally, only non-vaccinated crew members will need to be under restriction, and crew members that are vaccinated can still work. The only exception is for crew members that hold essential position, as they can still work even if they're not fully vaccinated, but they need to be asymptomatic, you see. And even with these two options, 14 days quarantine, mandatory quarantine of the vessel can still be imposed by the health authority if they decide that the public health is at risk, or it's the end, if they checked, or if they think there is any suspicion of a VOC or a VOI without the sustained transmission here in Brazil. So if there is a suspicion of like Delta or Omicron strain on board, the local health authority here in the port will probably demand a 14-day vessel quarantine here in Brazil. And of course, the ship owner can choose between these three options, but he will need to take into account the port location, his itinerary, the availability of alternative crew members in operational and logistical capacity necessary to implement the chosen option. And of course, the local health authority will always need to approve the option chosen by the owners or managers of the vessel, considering the vessel epidemiologic situation here and how the condition of the crew members also. And when the vessel has 100% of crew fully vaccinated, the ship owner or manager is exempt of having to choose one of the three options. There will be no problem of the vessel resuming operation or navigate to the next port call if all the crew members are already vaccinated. So what we recommend here in Brazil is to have all the crew members, all the seafarers on your vessel fully vaccinated, so you don't have to suffer any delay on the voyage on having to do a onshore quarantine or a aboard quarantine in your vessel, or having to stop and halt all the port operations also on the vessel. And keeping this in mind, here in Brazil, and mostly the charter agreements here in Brazil, they use English law, and usually they use also arbitration clause in LMAA court in London, the arbitration court in London. So usually, and what we're saying to all of our clients here in Brazil is, bearing this in mind, you try to use on the charter agreements clauses that are favored and that probably won't have the vessel going to quarantine proceedings here in Brazil. Usually requiring the crew members to be fully vaccinated, and also always trying to add wording to the charter agreement that will be compatible with the quarantine, sanitary and quarantine norms here in Brazil also. Because a lot of companies here in Brazil suffered with the mortgage claims, and they suffered a lot last year with the mortgage claims being presented, because the vessel would come here to Brazil and would face quarantine proceeding for 14 days. And the thing is, here in Brazil, the quarantine usually is for 14 days, but every time a new COVID test is tested aboard, the health authority will impose another 14-day quarantine. So in some situations, we see vessels stayed here in local ports for 1 month or sometimes 2 months, because every time the health authority would go on board to do the testings, a new crew member will present symptoms or will be positive for COVID. So the 14 days quarantine can take a long time, you see. And if the consignee or if the charter don't have proper wording on the charter agreement, on some situation, he can be facing the mortgage claims here in Brazil by ship owners due to the situation here in Brazil and due to all the sanitary norms here in Brazil, you see. And one of also the main questions we receive almost daily from ship owners and P&I clubs here in Brazil also is, how is the port restrictions here in Brazil, and how is the industry facing restrictions here in Brazil?
Larry, I'm sorry, the time is coming out, so please try to be to go to the end, please.
Of course, Artnur, and this is the last thing I'm going to present here in Brazil, and are concerning the port restrictions and time bar. So I only need 1 or 2 minutes. So the port restrictions here in Brazil, since last year, the federal government issued a decree stating that the port activities and logistics are considered essential, so no restrictions can be imposed on port or logistics. The only restrictions that some ports are having and facing right now is the requirement for full proof of vaccinations. And regarding time bar here in Brazil also, last year we had a law coming into effect suspending all time bars here in Brazil from July 10 of 2020 until the 30th of October from 2020 also. So we had a suspension on our statute of limitation here in Brazil due to mainly to COVID, and we are always saying this to all of our foreign clients and P&I clubs and ship owners also, because they have to keep this in mind when thinking about filing claims here in Brazil or filing the mortgage claims, or when, of course, they are presenting defense for cargo claims here also in Brazil. And Artnur, that's the main things here in sanitary and quarantine procedures here in Brazil. We had a lot of change the last 2 weeks. Due to the Brazilian Supreme Court last week, probably we will face new regulation the next following days. And I will keep all you guys from Interlegal also updated of the situation here in Brazil. And please, if you have any questions, I'm at your disposal and all the disposal of all the people that are watching us from home also.
Thank you, Larry. Thank you for your input. It was a very nice introduction to Brazil. For me, it's a pleasure to have you on board for the first time at our online events. Hopefully, we will have you not only online but also offline. It's many years that we have not seen each other face to face. In the chat, no questions. Probably very short question is that many ports in Brazil. Just please give a general comment whether in all ports the situation is more or less the same. Because as we know, in countries with a big number of ports, situation usually differs because there are geographical peculiarities. It depends much on personalities of port managers, etc.
Yeah, here in Brazil, some ports are starting to require full vaccination. Here in Brazil also, a lot of questions that I'm receiving is regarding how is the lines and how are the lineups here in the Brazilian port, if there are congests like the ports in USA or in Europe, mostly on container trade. And we are not facing huge lines or huge lineups here in Brazil. Things are mostly the same as before the COVID. We are not facing a lot of trouble with this. We faced some troubles last year, but was mostly not due to COVID, but mostly due to Brazilian crop of soy and corn that we suffered a lot with the rains. But mostly we're not facing a lot of problems here with the lineup due to COVID. And there are not a lot of restrictions, but of course some ports, and because of the managing and the port authority, they're starting to require full vaccination if you want to access the port or terminal area. You see, Artnur? I cannot see you, Artnur.
Yeah, thank you very much. Thank you very much.
You're welcome. I'm glad to be here and hope to see you soon in person.
Thank you. Let me remind all of you that we have about 200 registered delegates, and all our records will be distributed together with presentations to all delegates. We see in the chat and we see questions by email from delegates that they would like to have links to records of this webinar. So there is a nice feedback, and probably the last but not the least, we have our headliner finishing our webinar. This is Big George George Chalos from Big Apple, New York. Come on, New York. Good morning, Mr. Chalos.
Good afternoon, Artnur. It is morning here. It's a great pleasure to be here and great pleasure to share a few things about the American legal system.
Come on.
I'll share my screen. Okay, has my PowerPoint come across?
Yes, yes, fine.
Okay, well, good afternoon to all. Just a short presentation on everything you need to know about U.S. litigation. In the U.S., we have a tripartite system of government where power is split between the executive branch, the legislative branch, and the judicial branch. And our Constitution provides power and authority to the judicial branch to act as well as splits authority between the federal government and state governments. In the US, we have 50 states and a number of territories. A graphic to describe the two parallel systems. As you see on the left-hand side, the yellow boxes describe the federal system. The court of first instance is known as the U.S. District Court. Appellate matters go to U.S. Courts of Appeals or Circuit Court of Appeals, and anything that goes beyond that would be heard by the U.S. Supreme Court. On the right-hand side, we have a graphic that describes almost every state court system. We have our courts of first instance or the trial courts. From there, matters would get appealed to an intermediate appellate court. If worthy of further review, the matter would be elevated to a state Supreme Court. And then again, if it presents significant questions of law, it's potentially possible for state court matters to be elevated all the way up to the U.S. Supreme Court. Here is a graphic which describes the federal system in a very concise way, and we'll start at the 2/3 of the way down where it says trial courts. We have 94 judicial districts, we have U.S. bankruptcy courts, and then we also have the U.S. Court of International Trade and the Court of Federal Claims. Although they are robust courts, it's not something we ordinarily see in those matters that fall within those courts are few and far between. From there, we have 13 courts of appeals. There's 11 numbered circuit courts. There's the District of Columbia Circuit Court, and then there's a Court of Appeals for the Federal Circuit, which again is specialized for certain matters involving the U.S. government mostly. And sitting on top is the U.S. Supreme Court. Now, that's not the full universe of courts, as you'll see at the bottom of the photo here, that there are other courts, but they fall outside of the judicial branch of our government. Military courts, courts of veteran appeals, tax court, and administrative agencies and boards. Here's the graphic which will show you the 11 circuit courts, and you'll see that they're split up by geography. In New York, we sit within the Second Circuit Court of Appeals. Our Houston office sits within the Fifth Circuit Court of Appeals. And in the bottom right, our Miami office sits within the 11th Circuit Court of Appeals. Now, a fun fact, as you see the graphic here, the 10th Circuit, if you follow my cursor, is over here. Now, this photo or this graphic is not quite right because the 10th Circuit also includes a small piece of Idaho and a small piece of Montana. And you're probably wondering, why would they do that? It seems pretty neatly split up along state lines. Well, that's true. But right over here in this corner of Wyoming is Yellowstone National Park, and it spills into Idaho and Montana. So in order to make sure anything that goes down on federal lands in Yellowstone National Park, it falls within the authority of the 10th Circuit Court of Appeals. How do we get into the federal system? Well, it's not necessarily something you can do as a matter of right. The dispute there's three ways, generally speaking. The dispute ordinarily needs to involve a federal question, and that falls under either a question of constitutional law, a federal statute or regulation, or some other sort of treaty or international treaty that the US government has a national interest in deciding. A second way to get in is by diversity jurisdiction. And that is where you have parties on either side of the dispute coming from different places, right? A New York company versus a Greek domicile company, a New York company versus someone from Southeast Asia, wherever it is. It may also involve a Texas company versus a California company. Why? Because the idea, generally speaking, is to avoid home cooking. You don't want to be a foreign company or a foreign party in a particular state that you may have very little connection to. And of course, admiralty jurisdiction. Our judges, our federal judges, which is different than state judges, are nominated by the President of the United States. They must be confirmed by the Senate. Each of our states, each of our 50 states has 2 senators. And once confirmed, the judge receives a lifetime appointment. Let me say that again, a lifetime appointment. They get old, some get a little crazy, some might even be non-compos mentis or senile. But guess what? They're still appointed as judges and they still hear not just civil cases, but also criminal cases. It's a little strange, but that's how the system works. Now, in our state courts, we have 50 states and 5 territories. And of course, there are also specialty courts that fall within the state court system. For example, civil courts, criminal courts, family courts, probate courts. If someone dies, you have to adjudicate their estate and distribute whatever may be remaining behind. That goes to probate. Small claims matters. And different states have different rules on how the judges become judges. Usually they're elected, sometimes they're appointed, and every now and again there's a combination depending on the state. A strange thing is that some states don't even require you to be a lawyer to become a judge, but that's very few and far between. Our system in the US primarily comes from the English common law system, but again, it can't be that simple. We have one state, Louisiana, which follows civil law, and a territory, that's Puerto Rico, which follows a mix of civil and common law. I share now 2 separate slides that we've made into one, which describes the state court systems in New York on the right and Texas on the left. And you can see, looking at the graphic for New York, that we have a court of claims, a surrogates court, a Supreme Court, a family court, a county court, a city court, a district court, New York City civil court, New York City civil court. And you'll see how following the flow chart up, how it goes to an intermediate appellate term or an appellate division and up to the Court of Appeals. On the left-hand side, you'll see almost the same amount of information depicted slightly differently because the state court system in Texas is slightly different, but generally speaking, follows the same idea and protocols. Of course, the US is a proponent of arbitration. We have a Federal Arbitration Act, which sets out the legislative framework for the enforcement of arbitration agreements and arbitral awards in the US. Generally speaking, the rule is as long as your agreement is unambiguous, clear, and mandatory, 2 parties agree to arbitrate, that's where your dispute gets settled. Of course, we also have the New York Convention for the enforcement of foreign arbitration awards. Now, historically, the sales pitch for arbitration, at least US arbitration, is that this alternative dispute resolution mechanism should be more efficient. You don't get bogged down in the court system, which sometimes can take a year or 2, and now with COVID, 3 or 4 or maybe longer. It should be cheaper and it should be more predictable because you have subject matter experts that are deciding the issues. But the reality is that that's not always the case. And I would also venture to say that it's rarely the case, at least in our practice and certainly within recent years. For me, the most troubling part is that there are very, very limited grounds to challenge or overturn an arbitration award. I share the following picture, and I hope it's remembered, because the Federal Arbitration Act provides that if the arbitrators make a mistake of law in issuing their decision, they get the law wrong. You can't overturn the award. The rules also say that if the arbitration tribunal makes a mistake of fact, they get the facts wrong, the award will still stand, and there's no viable basis to overturn the award. And for me, the most troubling is the tribunal can make both mistakes of law and mistakes of fact. So they can screw up the law and get the facts completely wrong, yet the arbitration award will still stand. For me, very scary, very frightening. And while at one time we were very big proponents for US arbitration, and in the maritime context, the Society of Maritime Arbitration Forum, we're more guarded in our recommendations. That said, there are many, many excellent arbitrators. And when we are called upon to give our opinions on whether to arbitrate or not, our standard advice is yes, but make sure you get a good arbitrator, because if you get someone that doesn't really understand the issues or the law, you can have a real disaster of a decision on your hands very quickly. Now, my presentation could have been limited to just this slide, because this slide is the graphic that tells us the story from start to finish in US litigation. And if we move from left to right, you'll see we go from the top line to the bottom line, up and down, up and down, up and down, all the way across. When someone comes to start a case in the US, you've got to do your legwork up front, because you don't want to go into court and be unsure of the law or unsure of the remedies or unsure of your entitlement. So we say, look, you got to do your legwork and engage in the pre-filing investigation activities. And then once, as we move down along the line, once you're ready to go, you start your litigation, you commence proceedings with the filing of a complaint. In some jurisdictions, it's known as a petition, but generally speaking, it's the opening pleading to start the lawsuit. An opponent will answer, sometimes present a counterclaim, sometimes present a third-party claim to bring in other parties who may be responsible for the claim damages. Litigants, of course, are entitled to challenge the propriety of the litigation as a threshold matter. We often see what's known as motions to dismiss. Jurisdiction is always a big issue, and if you select a jurisdiction which is not appropriate to hear the dispute, you can expect to receive a motion to dismiss for lack of jurisdiction. Assuming you filed in the right place, assuming the court agrees that the case should proceed on the merits, then you get to what we call fact discovery. You exchange documents, you can ask for different documents, you can make requests for admissions and questions that are called interrogatories, all on written submission. And from there, we move to the deposition phase, or sometimes known as examinations under oath or examinations before trial. That's where the advocates sit down, previously in a conference room, now more and more by remote virtual means, where the advocate can pose verbal questions to the witness, to which the witness must answer. Of course, it's all under oath, and it's recorded stenographically by a court reporter, and it also can be recorded by video and audio as well. Once fact discovery is complete, we move on to expert discovery, which could include technical experts, liability experts, damages experts. And again, oftentimes, depending on the forum, there could be reports that are exchanged or just brief summaries of the anticipated testimony, and an entitlement to depose the opposing experts. Almost always, both sides will engage experts. One will say, I like chocolate, the other will say, I like vanilla, and it becomes a battle of the experts before the tribunal. Once discovery, fact and expert discovery is complete, you move on to what we call the summary judgment phase. And that's where parties say, look, there's no real disputed facts, but as a matter of law, I should win because. And that falls on both sides of the dispute. I'm the claimant and I should win because fill in the blank. Or I'm the defendant, I should win because the plaintiff or claimant failed to make out its burdens. Here's why. And then that's something that ordinarily is required to be decided prior to moving on to the trial phase. But strangely, those applications often get, quote unquote, taken under advisement and not decided till after the judge gets to hear more about the dispute at a trial. As we move into the trial phase, oftentimes the advocates will present what we call pretrial motions or motions in limine. There'll be an exchange of expert and witness lists, and in matters where juries are seated to be the arbiter of the facts, not the law, just the facts, both sides would propose jury instructions, which the judge would decide which side is more correct. We have pattern jury instructions for most of our courts, but not all of them. And again, just because there's a pattern jury instruction available to look at as a model, doesn't mean it fits neatly to your particular dispute. And so the parties would present competing interpretations of how it should be presented to the jury. And then we get to the trial. You've seen it on TV. There's an opening statement. You call your first witness, and you present your factual evidence. You present your experts. And at the end of both sides presenting their case, we have closing statements or closing arguments where the lawyers try to tie it all together and sum up why each side thinks they should win. Of course, that's not necessarily the end of the story. There are oftentimes post-arbitration, post-trial briefing, post-trial motions, and if you don't like the result, the matter can move on to the appellate stage, depending whether you're in federal or state court, will dictate how that procedure is to be followed. Now, jury selection and trial. We get questions about this routinely, particularly from insurers, whether it's P&I clubs or other insurers, because the concept of a jury trial is frightening. And it's frightening because we've all heard the stories about runaway verdicts, where a lady drives away from the McDonald's drive-thru and spills the hot coffee and says, it's too hot, and gets awarded millions and millions. It's crazy stuff. The picture on the screen now, you'll take a look. That could be any jury from anywhere, but this jury actually is an interesting one. This is a photo of the jurors from the O.J. Simpson trial. Everybody knows the actor and former athlete O.J. Simpson. We've never seen a jury in my 25 years of practice come to the courtroom dressed this nicely. Never. Of course, this was a highly publicized trial. It was on all the television stations for weeks and weeks in the United States. And of course, the jurors came in looking very sharp and very dapper for their big day on the television. In this case, although the case was to be decided, a criminal case to be decided, with the question being guilty or innocent, 12 jurors are called to decide. But due to the length of the trial, the high profile nature, and the fact that the jurors were going to be sequestered, meaning that they couldn't go home, they had to stay only amongst themselves during the pendency of the case, they sat 12 alternates. So the jury was composed of 24 people, and at the end of the evidence, only 12 would decide the question of guilt or innocence. A fun fact in this case, during the course of the trial, 10 of the jurors were excused and 10 of the alternates had to sit and decide the matter. You don't know who's alternates or who are the 12 first chosen jurors until after the case is finished. And that's standard no matter where you go. Legal costs and fees. We often get the question, well, wait a minute, if I go to the UK or other places, if I win as the prevailing party, I get reimbursed for my legal fees and other costs and expenses. Well, it's true that there are what we call taxable costs, such as the cost of transcription and things like that. The American rule says, well, absent a clearly worded agreement where a prevailing party is entitled to receive its legal fees, you're really obliged to bear your own costs. Again, I'll repeat it and say it slightly differently. If you intend your contracts or your relationships to provide for a prevailing party to win all costs and fees, you have to make sure you say it in your commercial contractual agreements. Now, this is unlike the prevailing practice in maritime arbitrations in the States. The Society of Maritime Arbitrators rules expressly give the arbitrators the discretionary authority to award costs and fees. And what we see is that arbitrators can award some costs and fees, all costs and fees, or none, even if you win. So that's a little unpredictable in how it works out. Now, why does maritime or admiralty matters go to the federal courts? Well, when the nation first started only a couple hundred years ago, the founding fathers decided that, we really need the shipping business and we need supplies to come in, and we need to, as net importers, we need to make sure that this is going to work smoothly. And so they decided that the federal courts were going to be the exclusive forum for any and all maritime suits, because the justification being that these matters involve questions of national importance. And this was set out in Article 3 of the Constitution, specifically saying that judicial power shall extend to all cases of admiralty and maritime jurisdiction. Now, the courts also quickly recognized, including the US Supreme Court, that shipping is different, right? All the other laws and all the business laws as they evolved in the new nation dealt with businesses that were right there on Main Street. They were right there. They were, you knew the proprietors, you knew the location, you knew what they did, what they made, what they sold. But shipping is different. And shipping is here today, gone tomorrow. As soon as the cargo operations are finished, the ship is out of here. And so the US Supreme Court said, wait a minute, shipping is transient. And cases that have looked at the issue have recognized what they call the peripatetic nature of our business. So they decided that we needed separate rules, and we have what we call supplemental rules for certain admiralty and maritime matters. And they provide different rules than what you find in land-based commercial law and litigation. For example, we have Rule B attachments, where you can go to the court on an ex parte basis and you can seize property. You can seize it as an ancillary matter to obtain security for a foreign case or foreign arbitration. You can proceed on the basis of obtaining security for a US-based litigation. You can also pursue a Rule B attachment to obtain what we call quasi-in rem jurisdiction. Even though there's no personal jurisdiction over the opponent, you have jurisdiction over the opponent because of the presence of its property here in the States. But of course, that jurisdiction is only up to the value of the property. We have Rule C, arrest rights. Again, an ex parte remedy where you go to the court and you can seize property, much like the Rule B attachment, on the basis of a lien claim. Also, we have the Limitation of Liability Act of 1851, which gives a ship owner the right to limit liability in case of a catastrophic loss of life, or other matters. Strangely, oil pollution falls outside of the scope of the Limitation of Liability Act, and essentially it's unlimited unless a responsible party can avail itself of various affirmative defenses found in the Oil Pollution Act of 1990. Now, we've talked a little bit about how cases get decided, and we have a distinction between jury trials and between bench trials. A few words on this. A bench trial means that the judge, he or she, becomes the trier of fact and the gatekeeper of the applicable law. So the judge decides what's the right law and what the facts are, and usually writes a written opinion, a comprehensive written opinion, which the parties will have an opportunity to review and then potentially appeal if the outcome is undesirable and there's a basis to appeal. But in jury trials, that's not the same. The judge becomes the referee of what the law is. And what we say is they call balls and strikes, using a baseball reference, on what are appropriate questions, what are the bounds of inquiry that an advocate may utilize. But the ultimate question in criminal matters of guilt or innocence, in civil matters of liability or not, are decided by independent jurors, and they're ordinary citizens that get called to the courthouse periodically, or usually based on voter rolls or driver's license records. And it's geographically based. So my driver's license has me in New York, my home is in New York, I would get called to the federal court or the state court in the county in which I live. And the same is true everywhere else in the United States. But the bottom line is, with COVID, it's been very difficult to seat juries because of the practical realities of people not wanting to come in, they're not wanting to congregate. We've had a few attempts at virtual trials. Some have gone better than others. We've had many, many virtual hearings with the courts around the country, which have gone very smoothly. And we've had many, and more as time's gone on, virtual arbitrations, which also have, generally speaking, proceeded smoothly. And that's pretty much it. That's the story in the US. If there are any questions, we'd be very happy to visit and talk about
it. George, thank you very much. You fulfilled my dream. During 20 minutes, I got understanding about legal system in the US. So it's thank you very much, because as always from you, it's very simple but informative. One question that I got, it's the issue that was raised by Krzysztof from Poland today. This is about new techniques and let's say online issues, virtual hearings. How is the system? How is the legal system in the US managed to adapt to new realities? What have you faced in your career during last 2 years as a challenge?
Yeah, Artnur, I'm glad you asked this question, because the answer is a crazy one. In the US, and I assume it's the same in other places, but particularly in the US, the entire pandemic and the response to COVID has been unfairly politicized. So remember, this kicked off at the end of the first term of Trump's presidency, where there was a major fight between the Democrats who wanted to take over versus the Republicans who were then in power. So what you were finding is that how business is being done, including the business of the courts, is largely dictated on the location that we're talking about and who is in power. And I'll give you a for instance. We have a tremendous amount of restrictions in what are viewed as Democratic controlled or blue states. As a matter of a demonstrative example, just this week, mask restrictions have gone back into effect in New York and California. If you go to Florida, which is a Republican controlled or red state, or Texas, which is a Republican controlled or red state, it's as if COVID doesn't exist. Business goes on as usual. So if you ask me what's happening in Texas, state and federal courts, it's business as usual. We put on our suits and ties, we drive to the courthouse, and we have our hearings in the usual way. Juries are getting seated periodically, not with the same frequency as before, because people still are reluctant. There are a fair percentage of there is a fair percentage of the population that's really reluctant. But as a general proposition, you do simple things like social distancing and wash your hands, and business proceeds as usual. In New York, we haven't been to the courthouse in 2 years. And there's no chance of us going to the courthouse anytime soon, whether it's state or federal. And what's bizarre about this is cases are moving, but they're moving exceptionally slowly. And as a result, I find that the practice of law has become less collegial, right? Before, you'd have to go to the courthouse, you see your opponent, you say, hey, we don't have to be back till 2 o'clock. You want to grab a bite for lunch, and you talk and you have nice interactions, and there's a human quality to it. But now everybody in the forums where you're not getting together, the advocates and litigators have become keyboard warriors, and it's become very nasty. It's really not nice.
I see. Yeah, so it's dramatic changes in New York particularly.
Well, you know, procedurally, yeah, I'm not sure substantively, but as it is right now, there is a major difference on how cases are being handled and progressed, depending on where we're talking about.
Yeah. I see it's generally, in general, I would say that, yes, by geography, by different, for example, in the US, it depends on who is in the power. But in other places, there are probably some other points that really influence the situation. But so it really differs now on the locality, let's say.
Sure,
Yeah.
for sure there is.
So in general, it's more local. It's more local.
Yeah,
George,
for sure.
thank you very much. It's a great contribution. Thank you very much for that you were with us. So we are coming to an end. The task was to support each other in these still turbulent times. But we have checked up, let's say, today what had happened during the last year. We had a nice talk, a little bit interactive from different corners of the world. Thanks to all speakers who supported our idea and joined our event. Special thanks to Inns Law Firm, to Julian Clark and George Zambartas. Their support is also great. We really appreciate it. All presentations and recordings will be distributed to 200 registered delegates. Thank you very much for your patience. Hopefully next year we'll see each other in presence at offline event, but in any case, we are together. Thank you very much. Ciao. Bye-bye.
Bye.